Yes, the matter, this is a file against the order of Lund Cat, and your lordship was pleased to pass an interim order. I am appearing for the opposite party number 6, who is the affected party. Yes, I have filed a interim application for vacation of stay. And
Accused in custody more than 8 years. Yes. Jail criminal appeal. Jail criminal appeal for bail. All the co-accused has been released on bail.
Beg your pardon for the indulgence. There is a criminal appeal also. Criminal appeal also. A petitioner wife is health hardship lawsuit. So no male member is there.
You have filed the bail application.
Lots of interim bail.
Keep the memo.
Pardon for mentioning, Lordship, it's a case matter. Service matter where the petitioner challenging the order passed by the CAT, rejecting the petition to file condonation of delay. Consequently, the review application was also dismissed.
Challenging the order of the state administrative tribunal. Administrative matter notice was issued.
Final hearing or final hearing.
One claim has been filed seeking restoration of a review petition which was dismissed on the submission of the then counsel that he has no instruction to appear on that matter. But the urgency is that this case directly affects the 15 pending cases which is now pending for the lawsuits.
What do you want?
I want it to be listed, my lords.
No, review petition has already been dismissed for non-prosecution, or he filed the memo that I do not want to praise the application.
The then counsel submitted that he has no instruction to appear on that matter.
Yes.
Have you filed a restoration application?
Yes, my lord. The same application.
Just
Yes.
Yes.
I filed 2 requisitions challenging the order on criminal matter. Case matters may be taken up for admission.
It is pending for final disposal. Please launch.
What is the read?
Read number 2.
No. What is the read for? What is the prayer?
That I don't.
Go through the file and then. All right. Yeah.
Supplemental list, item number 1.
lordship,
Petitioner challenging administrative 3.
Speak little louder.
Last opinion, posing a question regarding maintainability of the read petition.
Yes. We verified on that day, and someone pointed out that there is a provision to appeal before the appellate tribunal. So that is exactly the reason why we asked you to verify and regarding the maintainability. The provision electricity. Have you examined it or not?
Yes, Mr. Maharana.
Well, it's after the order passed by the learned GRF, the consumer has a remedy to go to ombudsman, whereas the licensee has to come in writ. But once the order passed by the ombudsman is rejected or allowed, being aggrieved, the remedy lies with the writ petition.
Writ petition.
Writ petition.
So this writ is maintainable according to you.
Yes, yes.
Writ is maintainable.
What about those provisions which we pointed out?
Regulatory authority. Jurisdiction of
That
regulatory.
is OERC, Malad sir.
OERC.
So far as the OERC is concerned, Malad sir, administrative superintendence lies with OERC above GRN of ombudsman. But so far as interstate dispute between arising out of
Just a minute. This ombudsman dispose of this representation case number so and so. This is under which provision?
Well, it's the ombudsman is given the power under section 42(6).
42. Please come to that. 42.
Section 42(6).
42, which subsection?
Well, it's if your lordship sees 42(5).
42(5).
For a moment.
Please place it.
Malas, every distribution licensee shall within 6 months from the appointed date or date of grant of license, whichever is earlier, establish a forum for redressal of grievance of the consumer in accordance with the guidelines may be prescribed by the State Commission. 6 Malas, any consumer who is aggrieved by non-redressal of his grievances under subsection 5 may make a representation for the redressal of his grievance to an authority to be known as ombudsman to be appointed or designated by the State Commission. This is Malat's constitution of the ombudsman.
Then
7 Malats, the ombudsman shall settle grievance of the consumer within such time and in such manner as may be specified by the State Commission. 8 Malats, the provision of subsection 5, 6 and 7 shall be without prejudice to the right which the consumer may have apart from his rights conferred upon him by those subsections.
So against this 42 6, let us say,
Mal.
we shall settle the grievance. Suppose any order is passed against any party
Mal.
by the ombudsman,
Mal.
you mean to say that
Only read like.
there is no provision in the Electricity Act?
Malats, in fact, after this on the basis of the power given to the commission under this act, the OERC, the Odisha Electricity Commission, has framed another rule which solely governs the function and administration of GRF and ombudsman. That is OERC Grievances Redressal Forum and Ombudsman Regulation 2004. If your lordship is holding the OLR book,
This is OLR
yes, ma'am. If your lordship sees page 678 of that book.
678. Just a minute. Yeah.
Your lordship will see that is Odisha Electricity Regulatory Commission bracket Grievances Redressal Forum and Ombudsman Regulation 2004.
Yes.
This is the regulation formed by a state commission exercising power under section 42, 5 and 6. And this regulates, Malats, what are the disputes that can be adjudicated by the GRF and ombudsman. If your lordship sees page 688. 688.
Yes.
Yes.
Well, this is a circular issued by the Energy Department and the Commission that these are the kinds of dispute which will be adjudicated by both the authorities. Thereafter, no appeal or revision.
Lies against.
Yes. Therefore,
So therefore it is better.
Yes.
You are appearing for whom?
Opposite party number 2. Your lordship had on the last occasion recorded. Copy I received yesterday.
You have received the copy.
I have received copy yesterday.
On merits, what?
On merits, what do you say?
The petitioner has applied for a new electricity connection for his shop. They have neither rejected nor supplied. Thereafter, he has filed a grievance petition before the GRF, who has directed under Annexure 3 to clear the dues of the original owner. Thereafter, he challenging this, he has referred a consumer representation case under Annexure 4. Thereafter, they have confirmed the order passed by the GRF under Annexure 6. Challenging which he has prepared the present petition. Here, my humble submission is that the dues relating to the original owner, the present petitioner is no way connected with that.
No way connected him.
You have given a written undertaking. Come to page 38. Last paragraph. Check the last paragraph. The present petitioner has also given a written undertaking to pay the outstanding arrears relating to the appeal number so and other pending dues of Alec Jena or his son or the legal heir in connection with the appeal. You have given undertaking, you have to pay it. That's all.
Relating to meter tampering matter, the case is adjudicated here before this honorable court. That account he has paid already 50% of this amount.
No, we do not know. Suppose one building where the electricity is used is occupied by X, right? X use korthila, X to Y taku nela. Ebong taro undertaking dela je taro X ro jaha outstanding dues achi I will pay. So he used it and did not pay. Then again he will, after it escalated, he will again transfer it to Z. So what about the electricity dues? So in this matter, It will go on and on. So once you have given the undertaking and it is an agreement between X and Y that you are to pay
There
the,
is no agreement related.
No, then next paragraph, just see. Read it next paragraph. Right, further. The petitioner has given clear and positive undertaking to pay any pending dues of the original owner of the land and building.
if claimed by the TPN or DL in any future order.
Condition is that the case is pending before this honorable court. So that is not yet been adjudicated. So he is.
Whatever, but you have given undertaking, you have to go by that undertaking, that's all.
Yes, yet not been decided. Tampering has not been proved yet, man. So that apart, he has already paid 50% of the amount.
Now pay another 50% and finish it. That's the
Whether, suppose, you have taken that, house on rent or what?
Yes, ma'am.
So you have-
The shop, ma'am.
Shop, right? So the owner, against the owner, the allegation is that he was tampering the. So why did you give such an undertaking? You know that the tampering is there, the owner is facing a prosecution under the Electricity Act. Then why you gave the undertaking that I will clear all the dues of my owner? And now you will say that no, I will not pay and.
No, he has purchased and running a medical wholesale business from there. And it is like you can uninterrupted electricity freeze.
Freeze.
Definitely upon use it. And 41,
Another
sorry,
thing, ma'am.
page 39 last. Page 39 last cover. Last paragraph. Petitioner in this case. That is, petitioner in this case has categorically admitted in para 3 of the petition that he has been running a medicine wholesale selling business in the room number 1 of the building of election against a huge outstanding areas payable to license. When the petitioner has stated that he has been running a medicine wholesale selling business in the premises prior to his application for new connection, and he has not clarified and explained the authority and so.
Neither they have rejected my application.
See, you are running a
nor the
business.
also.
You are running a business from that premises,
Yes, sir.
and you are using electricity. Over and above that, you have given an undertaking. That is the reason the courts, the authority says that you discharge all the liability. Then only
Rejected my
connection.
application, ma'am. Not return the amount, ma'am.
Yes, anything can be helped to this man.
Let's, if I may clarify, my lords, what has happened, my lords, 2 reasons his application has been rejected. One, my lord,
Not rejected yet, ma'am. That is rejected.
Send it to mediation.
There is a direction to deposit the
Send it
amount.
to mediation.
Either rejected nor return the amount.
that's
Mediation put
the owners, the premise owners,
The order has been passed against you. Why you say, in view of the above facts and circumstances, the authority by upholding the order number so and so passed in case number so and so of the, dismiss the case of the petitioner, and you say that it is not dismissed? देखी ना दी so operative court
They have
portion
found, they have found, Annex, your lordship may see Annex 3.
ଆପଣ ବର୍ତ୍ତମାନ କହିଲେ ଯେ ଆପଣଙ୍କ ଏଗେନଷ୍ଟ କିଛି ଅର୍ଡର ପାସ୍ ହେଇନି, ଆପଣ ଯୋଉ ପିଟିସନ ଟା ଦେଇଥିଲେ ଏଟା ପୁରା ଡିସମିସ ହେଲା, ଅର୍ଡରଟା ଏଗେନଷ୍ଟ ହେଇନି, କଣ ଆପଣଙ୍କର?
My representation case they have dismissed, ma'am. But my connection, what my application, they have not rejected.
all these things, so it's all right. But in a read jurisdiction, to what extent we can stretch?
So if anything can be sorted out between the parties by way of mediation, that's all right, but
We can think of sending it to mediation.
Yes.
go for mediation, we are sending it.
Try and help him out.
my lords, it's that instruction.
50% he has paid.
My lords,
Remaining 50% is.
I will, let's assist my lordship on that, but
ତାକୁ installment କରିକି କେମିତି କରି ତାର business ଟା ଚାଲିବ କେମିତି ସେ ବିଷୟରେ ଚିନ୍ତା କରିକି ଇଏ କରନ୍ତୁ, mediation ପଠଉଛୁ, mediation report ଆସୁ ଦେଖିବା।
High Court mediation.
ହଁ High Court mediation।
dispute ହେଇଛି once the owners and his sons, 5 already consumer thile, the owners and his son categorically year after year indulge in theft. 4 number of proceedings were initiated. By the time he was there, once we initiated a proceeding upon the father, next son creates another assessment, then next. So 4 theft cases have been done. Now, when we initiated theft case, the person who was already extracting electricity using that unauthorized construction, he filed an application. In the application, he mentioned himself to be the owner. And in the second column, there is a category, whether you're owner or a tenant. He clicks on the owner. Second category, there is a declaration, whether any assessment or theft case or anything or outstanding is due against that premise. He says no. Thereafter, when we inspected, we said that the owner has imposted him that since I cannot apply for new connection, you apply for new connection. So he applied for new connection. We conducted an inspection. We came to know that under those premise, there are 4 cases pending. So that is how the ombudsman has rejected his application on 2 accounts. One, a false declaration in the application that he is the owner, whereas in the writ petition, he accepts that he is a tenant. So his application itself is a false application. That is how it has been.
Better see 3 cases are there against you. Better that you settle the dispute and pay the money and finish it up.
Honor out of 3টা পুরো না রে 4টা কেস
ସବୁ ଜାଗା settle କରିଦେବ।
ইয়ানার কিছু ক্রিমিনাল কেস ହେଇନି but
So under the regulation,
these are all those matters are compoundable offenses. Say electricity act ର theft of electricity ରେ এটা compoundable offense. ତେଣୁ ଆପଣ ଓନର ଙ୍କ ସାଙ୍ଗରେ କଥାବାର୍ତ୍ତା ହେଇ mediation
already
the
old interim order also to the effect not to disconnect the electricity now. So that has
not to disconnect electricity ଆପଣ ବର୍ତ୍ତମାନ ନ୍ୟୁ ମିଟର ଆପଣ ଚାହୁଁଛନ୍ତି ପୁରା ନ୍ୟୁ ମିଟର ଦବାକୁ ତାଙ୍କର ଅଛି ଯୋଉ ପ୍ରିମାଇସେସ୍ ରେ ଏଇ ଟାଇପ ର ହେଇଥିବ ଆଉଟଷ୍ଟାଣ୍ଡିଂ ଡ୍ୟୁଜ ହେଇଥିବ ଥେଫ୍ଟ ହେଇଥିବ ସେଠି ଦେବେନି ତେଣୁ it will be proved in due course of law.
It has been finally done, during the pendency of the writ petition. Those proceedings are already concluded.
Better is there.
And writ petition is pending, concluded by the authority.
The grievance of the petitioner in this writ petition is to set aside the order dated 12/1/2024 passed by the London Ombudsman so in consumer so whereby the order dated 7/11/2023 passed by the so has been confirmed. The on the last date, we asked the London Council for both the parties to examine regarding the maintainability of the writ petition against the order passed by the Ombudsman. The London Council for the opposite party placed the relevant provision of the Electricity Act, so also the Orissa Electricity Regulatory Commission Grievances Redressal, CORAM and Ombudsman Regulation 2004 and submits that there is no other forum for the petitioner to challenge the impugned order under Annexure 6 except approaching this court in a writ petition. Stop. Accordingly, we hold that the writ petition is maintainable. After hearing the Land Council for both the parties, we think it proper to refer the matter to for mediation to the High Court so mediation center in Nanda. The report of the mediator shall be placed time they going to achieve subject.
The coordinator of the mediation center exactly what it to issue notice to all stakeholders.
All stakeholders. The coordinator say issue karibo to all the
stakeholders.
Format achi taku ye karibo. Report ta de debe oda time limit debe tapore matter list karo. Yes.
So only if I may be permitted, on the last occasion I was not present.
No, what is your good name?
Lalit Kumar Maharana.
Your name is there, it will be reflected in the positive.
It's there.
Yeah. Yes, next.
Item 2.
Power Dina.
In fact, on the last occasion, it had come for the first time. Your Lordship, somebody pointed out that my learned senior appearing for the petitioner pointed out that I usually appear. So this is my first date of appearance.
No, that is why it has been pointed out by the registry that you have not filed wakalat.
Yes, I will. Yesterday I just received the copy, so I've intimated. I'll file with the wakalat.
All right, Mr. L.K. Maharana, Land Council submits that he will file the wakalatnama by next week or
By next week.
By next week. The notice for me, I'm going to put it in the Tankar mediation center a case would have given, so it will take some time. Is item number 2 you want pass over?
Yes.
Item 3.
Maybe. Yeah, conviction for life on the figure 2.
This is writ petition. Come after the lunch.
You have filed a
Sorry, sir.
writ petition challenging the trial court judgment. We are dismissing that. Here. Item number 3.
Item number 3, actually similar to the 2010. And we taken off along with WPC number 11086 2025.
WPC number
11086
11086
2025.
2025.
Yes.
You, what is your good name?
Amit Sahoo.
A. Sahoo, Amit Sahoo Land Council, appearing for the petition that a connected matter by WPC number 11086 of 2025 is sub judice, and this matter we listed along with the said WPC. List this matter.
I am appealing for opposite party.
We commencing from 30th
Filing my
2025.
memo.
So files wakalatnama for the opposite party bank, which is taken on record. The name of the land council be reflected in the cause distance board. Have you supplied the copy of the writ petition?
In course of the day, I'll
Acha. Land council for the petition shall supply the copy of the writ petition to the land council for the opposite party bank during course of the day.
in course of the day.
Yeah. It is the
In the memo, undertaking file my wakalatnama.
He has filed a memo to seeking 1 week time to file the wakalatnama. So on so 30th October, by next date you will file the wakalatnama.
Okay, sir, I have already entered appearance.
All right. Okay.
Item 4.
Item number 4 may be taken along with item number 9. I am waiting. Item number
19 Soito
Item 5.
Mr. Guchar, Central Government Council. Upon comprehension, the opposite party. They will file it. Pass over could.
Pass over.
All right.
Item 6.
Yeah.
One of our challenge, the order passed by the central tribunal. And then passing the order. The petitioners, in directing the opposite party to cooperate with the departmental inquiry, which has been directed by the revisional authority. And the order influence, Lordship kindly have a glance to the relevant paragraph. It page 84.
Yes.
84.
Running page 122.
No, one page 184.
Internal page of the page. You are challenging annexure 3.
No, sir, Malay is implement order.
Okay, implement order is annexure 3. And
Paragraph.
it appears that one Purnendu Sekhar Pati filed the original application.
Yes, madam.
What was his prayer before the land and
Prayer before my lord, I am submitting in brief, my lord. The case is that he is the senior super, my lord,
section officer?
engineer.
Yeah.
My lord, he was against whom, my lord, 30 numbers of employees of railway, my lord, they have alleged that he has misappropriated and some money has been, my lord, cost to the loss to the department, for which they have made a petition, based on which inquiry was directed by the department, and while inquiry was going on, my lord, he didn't participate and rather he made an application to the disciplinary authority to change the inquiry officer. And based on that, his inquiry officer was changed and subsequent inquiry officer was appointed. Inquiry, he was asked to file reply, but he didn't, instead of filing reply, he submitted application for adjournment of the inquiry. And thereafter, he didn't participate in the inquiry, even though it was adjourned from time to time. Thereafter, expert inquiry order was passed, based on which, my lord, he was asked to show cause against the ordering punishment. He didn't reply it. Order was passed, ordering punishment of reversal. Thereafter, he preferred appeal. In appeal, it was confirmed. Again, he, my lord, thereafter, instead of preferring revision, he seek my lord, redressal of the land tribunal. Land tribunal remitted it back to the appellate authority for fresh consideration of the appeal. Thereafter, again, appeal was upheld, my lord, the punishment. Thereafter, again, he filed original application. Again, the land tribunal remitted it back to the appellate authority. Thereafter, my lord, he filed again, according the order was passed, he moved to the Honorable High Court. My lord, entire matter was how to delay the matter. He moved the Honorable Court, High Court. Honorable High Court remitted the matter, directing him to approach the revisional authority. He approached the revisional authority. Revisional authority confirmed the order of the appellate authority. Thereafter, he moved the tribunal. Tribunal again, my lord, remitted it back to the revisional authority. At that time, revisional authority, while considering revision, found that inquiry has not been completed, it has been exported. For that, a lenient view was taken and the direction was given to, and the punishment order was set aside. Appellate disciplinary authority has been directed to proceed with the departmental proceeding affairs inquiry at the inquiry stage. My lord, this order was directed by the revisional authority. Thereafter, the appellate of the disciplinary authority, what did? He directed the petitioners to cooperate with the inquiry matter. Because he was, by that time, it was of the year 2006, and this order has been passed in 2023.
ଆପଣ ଯେତିକି କହିଲେଣି ସେ ଯୋଉ ଗୋଟେ ଗପ ଅଛି ସେ ରାଜା କଣ କହିଲେ ଏମିତି ଗୋଟେ ଗପ କୁହ ଯେମିତି ଗପଟା ସରିବନି। ସେ ସେଠୁ କହିଲା ଗୋଟେ ଚଢେଇ ଥିଲା ସେ ତା ଛୁଆ ପାଇଁ ଖାଇବାକୁ ନେଲା ସେ ଗୋଟେ ମାଟି ହାଣ୍ଡି ଥିଲା ସେଟା ଧାନ ଭର୍ତ୍ତି ହେଇଥିଲା ସେ ଆସିଲା ତାର ଦେହରୁ ନେଲା ନେଇକି ଥୋଇଲା ରାଜା କହିଲେ ତାପରେ ତା ପୁଣି ଆସିଲା ପୁଣି ନା ଧାନଟା ନେଲା ଥୋଇଲା ରାଜା କହିଲେ ତାପରେ ନା ଆଗେ ସରୁ ଆଗେ ଆପଣ ତ ଖାଲି କହୁଛନ୍ତି ସେଠିକି ଗଲା ପୁଣି ଆସିଲା ସେଠିକି ଗଲା ପୁଣି ଆସିଲା ଆରେ କଣ ହେଲା ପୁଣି କୁହନ୍ତୁ।
The disciplinary authority not rejected, directed my lord to participate in the departmental proceeding from the stage of inquiry. He didn't participate. My lord, the revisional authority has directed to my lord, he will be.
ଆପଣ ଯୋଉ ଅର୍ଡରଟା ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି କି ଅର୍ଡର ମୁଁ
What is your precise grievance, you tell us?
15 ମିନିଟ୍ ହେଲା ଆମକୁ ବୁଲଉଛନ୍ତି ଇଆଡେ ସିଆଡେ କୁହାଉଛି ଅର୍ଡରଟା କଣ ଚ୍ୟାଲେଞ୍ଜ ହେଇଛି ବୋଲି ଆପଣ
The order imposed before the Lord Tribunal, page 53. 53.
Annexure?
Annexure, my lord.
You are challenging the order. You said that annexure 3 you are challenging.
No, that is, my lord, imposed before the Lord Tribunal.
What is the final order you are assailing here?
Final order, the Lord Tribunal directed.
Where is that order?
That in 84.
Yes.
Annexure 3 is the order you are challenging.
Yes.
Let
us come to the
operating
portion of the order.
You got, you are aggrieved.
Page 84.
84, yes. Read that.
Come to paragraph number 6.
Yes, Lord. we have considered the rival submission of the respective parties and trials on record. It is not in dispute that major penalty proceeding was initiated against the applicant by the memorandum number so dated P9/2024 and by the order dated 24/5/2006. The applicant was faced with the punishment of reversion from the post of senior section engineer works in the scale of pay of rupees so and so to the grade of section engineer works in the scale of pay of so and so for a period of 2 years on cumulative basis. During the period of penalty, basic pay shall remain fixed at rupees so and so, and during this period, the DNS pay and the DNS allowance shall be calculated on the basis of fixed pay of rupees so and so. On completion of the period of penalty, his future increment shall stand postponed by these 2 years, and the seniority shall be adversely affected accordingly. Be that as it may, complaints of the order of the tribunal, the authority concerned consider the events of the applicant, and by order dated 29/2022 set aside the order of punishment which was upheld by the revisional authority by the order dated 23/11/2022. It is also admitted fact that press inquiry proceeding in pursuance of the memorandum dated so is underway. On the order of punishment.
Once the order of punishment.
Once the order of punishment is set aside, obviously the axiomatically the punishment imposed on him is no more available in the field, and the implication of the imposition of penalty, including benefits which were upheld because of the punishment order, ought to have been restored in favor of the applicant.
Yes.
The respondents did not produce any authority, rules of law to justify their action that in the above circumstances an employee is not entitled to the benefit. In the above circumstances, we find sufficient force in submission of the land counsel for the applicant and then.
What is wrong in it?
What is wrong?
The wrong is, my lord, lordship, what the disciplinary authority have directed. The disciplinary authority, it started, my lord, the departmental proceedings started from 2004. He has filed many applications, many original applications, moved this and.
We need not go into that entire story.
No, my lord.
The simple fact is,
He is not
one minute. The simple fact is, now a fresh inquiry has to be conducted. Okay, once the fresh inquiry is conducted, the earlier punishment which was imposed on him, that is not effective. That's what the tribunal says.
Yes, ma'am. That is correct. But
The fresh inquiry will culminate into a penalty.
No, what he has challenged.
And how can you continue the penalty and continue the fresh inquiry also?
No,
so
no.
The penalty which has been imposed pursuant to the earlier proceeding has to be given no effect to that.
Yes.
That's all. That's what the tribunal says.
Lordship, kindly have a glance to page 53. What was impugned before the law tribunal? That is, my lord, page 53.
Yeah, are you agreeing with the logic, the reasoning of the tribunal insofar as para 6 is concerned?
No, my lord,
are you disagreeing or agreeing with
the law tribunal, instead of directing, my lord, the delinquent who is not cooperating with the departmental proceeding, what has been directed,
those things has become history now.
In view of the revisional authority's order, lordship, the proceeding has been remitted back. The proceeding again, my lord, has been remitted back to the question of inquiry in view of the revisional authority's order. Instead of, my lord, participating in the proceeding or
participating, we do not find any merit.
Page 53, lordship, kindly see.
Yes.
The department.
We have taken a lot of time, like on this writ petition has been filed by the Union of India and others, challenging the order dated 31/10/2024, passed by the London Central Administrative Tribunal, Cutter Bench, way number 91 of 2023. It appears that the opposite party, number 1, Purnendu Shekhar Pati, filed the aforesaid way with a prayer the prayer portion to relief sought for achieve, page number 31 and 32, সেটাকে লিখে দেবে ହେଲା paragraph number 8 রয়েছে তার original application no prayer আছে. The learning tribunal সেটার মধ্যে একটি কোর্ট হয়েছি অর্ডারের কোর্ট হয়েছি page 82 internal page 3 এর মধ্যে কোর্ট হয়েছে.
Yes, ma'am. Page 8.
The learning tribunal, after hearing the learning counsel for both the parties, has been pleased to observe as follows, quote paragraph number 6 and 7. After hearing the learning counsel for the petitioner and going through the reasoning assigned by the learning tribunal, we find no infirmity or illegality in this. Accordingly, the petition being devoid of merit stands dismissed. Yes.
Item 7.
The order passed by the 11th Reducer.
My lord, may I audible, my
Yes, Mr. Pari.
my lord, item 5, I could, sorry to interrupt. It is urgent or Nurse will take
No,
up?
five, it was passed over, somebody made a mention, we called the matter, Mr. Gochait was not there and nobody, you want to place it, you can place, there is no problem, Mr. Pari.
My lord, it is a case where the issue is related to postal department recovery of 90,000 only.
Just a minute, prayer portion is, item number 5 you are placing and you are challenging the order dated 23/7/2024.
Exact on page 27, yes, Annex 1.
Yes.
Yes. And that tribunal is allowed not to quashing the charge sheet issued by the authority. Our stand will be the tribunal didn't have a power to quash. I'm just reading my lord page 42. It starts from 41 itself, paragraph 14. May I read my lord?
Yes, please place it.
In view of the discussion made above, I am of the considered view that the charge sheet being vague and unspecified deprived the application the principle of natural justice and meeting and relying the same effectively. Hence, the applying the law laid down by the Honorable Apex Court discussed above, the charge sheet dated 31/5/2019 is hereby quashed. The circumstances by applying the law that the initial action is not consistent with the rule and law, subsequent proceeding must fall since the illegal strikes all the roads in the matter. The order of the disciplinary authority as well as the appellate authority, besides the laxity discussed above, are also held non-ist in the eye of law and is hereby quashed. My humble submission. Then Lord may come to the. I'm reading completely. We would have to remit the matter back to the respondents for taking steps for accordance with the rules, but keeping the mind fact that the responding rule 16 and the applicant has the meantime retired from service. I returned from the ordinary. Subsequently, the respondents are directed to refund the already record amount within a period of 30 days from the twofold we have a grievance filed. One, the tribunal didn't have a power to quash the charge sheet issued by the wrongly right because there is a forum who can adjudicate the same. That didn't prefer the revision. Suppose a appeal is there, appeal is confirmed, he is agree with this, there is evidence there. But my lord, unfortunately, this ground has not taken in the writ petition. I'm sorry, my lord. There is a law prevails that if after the appeal.
Have you, Mr. Pari, the learned tribunal has been pleased to held that the charge sheet which has been filed against the opposite party is vague and unspecific. And if such a charge sheet is filed, then obviously he cannot know correctly what is the allegation against him so as to face the charges, and principle of natural justice will be flouted in that way. So that is the reason, relying on the Honorable Supreme Court decision, the charge sheet has been quashed. So if you say that the tribunal has got no power, then the thing is that you have to file the charge sheet for examination whether it is vague or not. Number two, according to you, if such a charge sheet is filed and the petitioner is aggrieved by such charge sheet, what alternative remedy he has to got
Yes.
to challenge the charge sheet?
Oh, my lord, in this respect, one respect, I am meeting my lord's query that we have a decision of this Honorable Supreme Court that the tribunal didn't have a power to pass the charge sheet. My lord, on the next date, let's me keep it to next date, I'll file the charge sheet. Page 75, we will file the charge sheet, my lord, it is on the record.
In page 33, the charges are extracted.
Yes.
The charges on the basis of which you are proceeding against the respondent is extracted there in para 4 of the impugn order.
My lord, if let's me give me another date, I'll make a compilation note, then it will be.
Because number of Supreme Court decisions have been discussed in paragraph number 8, which also says that if such type of charge sheet is filed, then it can be quashed. So all right, you examine it, and paragraph 10, it has been mentioned also in the impugned order that on examination of the charge sheet with reference to the law discussed above, I do not have any iota of doubt to accept the stand of the applicant that since the charge was vague and unspecific, he was deprived of reasonable opportunity to file his reply effectively. So the charge must be specific so that somebody has to give his reply and he has to face the proceeding ultimately. But if it is not specific, that is how it goes to the root of the matter. And the Honorable Supreme Court says that in such a circumstance, it can be quashed. And he has challenged it ultimately. All right, you want to take time? You want it next week or what, Mr. Pari?
Yes, sir. After 10 days, I need.
All right. This writ petition has been filed by the Union of India and others, challenging the order dated 23/7/2024, passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack, under Annexure 1, in allowing the original application filed by the opposite party number 1, Rajendra Kumar Patnaik, and thereby directing the petitioners to refund the already recovered amount within a period of 30 days from the date of receipt of the order to the opposite party number 1. It seems that the London trial court not only discussed the facts, but also taken note of the decision of the Honorable Supreme Court in that respect. Mr. Padi, after arguing the matter for some time, seeks for an adjournment, submits that there are contrary decisions of the Honorable Supreme Court which he wants to cite on the next date, and stop. This matter in the week commencing from, whether it will be on 30th, Mr. Pari, or you want some more time?
My lord, immediately.
30th of June 2025.
Problem.
You are appearing for some. To also file wakalatnama for the opposite party. Have you received a copy of the writ petition? Mr. Pari,
Yes, my lord.
the
Full copy,
London Council is
yes.
appearing for the opposite
yes.
party you supply.
I'll supply the
Copy
Mr.
of the writ
Mark.
petition be
Yes.
supplied to the
Too
London
much.
Council for the opposite party in the meantime. Huh? Number 5 it is.
Item 8.
Very good. Item number 7.
Item 7.
Yeah.
Now, the order passed on the Annex 5 by the Grievance Redressal Forum at page 40 Miller, directing the distribution licensing law to
Which order you are challenging?
that order of Grievance Redressal Forum directing for shifting of the
55.
11 kV overhead line, which was drawn much before 2005 Miller. And Miller, of course, because of this circular Miller, where the unauthorized installations are made.
Against this order, whether there is no, you can approach the ombudsman. I think it was known
We
to.
have no license, has no scope, where the order has been passed by the Grievance Redressal Forum, because it is the licenses forum, and remedy is available to the consumer Miller to approach the ombudsman. That is in nature of appeal. And for the license, the door is closed, Miller. And here is a case, Miller. Grievance Forum is only authorized to hear disputes.
You are a license.
Yes, Miller. Between the consumer and the licensee. Here, Miller, the applicant is not a consumer. He is an outsider. He made an application praying for the shifting of the 11 kV lines run since long, alleged to have been done over his land, Miller. And it is the work coming under the work of licensee rules, Miller. Miller, where the work has been done or where the work is going to be done, it is to be undertaken by the collector, Miller, district magistrate, Miller, as per the workshop licensee rules, Miller.
Let us see what are the reasoning.
Miller,
What is the reasoning given by?
Miller, the reasoning, Miller, the JRF has appreciated, from JRF has said, Miller, there is one regulation, that is government order, Miller, in the order portion, page 40, the JRF has quoted. The respondent is hereby directed to produce the documents as evidence to the complainant as proof that the 11 kV overhead lines was constructed before passing of the order by number so and so dated 20th February 2009 by the Commissioner cum Secretary Department of Energy, Geo number Government of Order within 15 days from the issue of order. And upon fail to produce produced by the respondent, it would be presumed that the line was constructed unauthorizedly and the respondent shall do shifting of the line from the plot of the complainant free of cost to the complainant. Lord, that circular I have annexed before your lordship at page 47, page 45 to 48, that is the circular, Lord. Your lordship has a glance to clause 10. At page.
What is the circular?
That government order it.
Online, please.
Page 49, clause 10.
See, heading was.
Heading hochi placing of electrical lines for electrical plants for the transmission of electricity or for the purpose of telephonic or telegraphing communication.
Yeah.
It's a Energy Department notification order dated 20th February 2019. Simultaneously, your lordship's attention may be drawn to page 49, clause 10.
49.
Same circular, running page 49.
Yes.
It says electrical lines and electrical plants placed before passing of this act. Every electric line or electrical plant placed before the passing of this order, over, along, across, or in or upon any property for the purpose of a power system established or maintained by the state government, the state electric board, shall be deemed to have been placed in exercise of powers conferred by and after observance of all the requirement of this order. Now, my lord, now subsequent to this order, if the license has installed something, my lord, or going to be installed, then permission is necessary, owner's permission. Here, my lord, the line which has already been done prior to passing of this order, my lord, that will be deemed to have been done with the due permission, my lord.
But
shall be deemed to have been placed in exercise of power conferred under the or after observance of all requirements.
But CGRF has only asked you to produce the documents only.
Documents we have produced, Miller.
No, come to the operating part, page 40.
Yes.
What was the order?
Yes.
Page 14. No, order is this order we have
Respondent hereby directed to produce the document
Yes, my lord.
as the evidence to this. Let the documents be. Let there be a final order.
Sir, ମୁଁ ଏଇଟା ଫାଇଲ କଲି 1/5 ରେ ମତେ ଟିକେ କମ୍ୟୁନିକେଟ କରିବା ସେମାନେ ମୋ ପାଖକୁ ପଠେଇଲେ ଡେରିରେ 7/5 ରେ
That's a different cause of action altogether. Now,
pursuant to this order and prior to filing of the writ petition, the license has communicated to the consumer, that is the applicant, consumer. No,
where is the final order then?
এটা স্যার 29/4/25 রে অলরেডি ଦେଇছে।
Where is the final order?
No, this order itself shows that
This circular will communicate the
no, it has been disposed of. Please come to the order.
Yes.
With the pronouncement, the case is hereby disposed of.
Yes.
If the complainant is not satisfied and aggrieved with the order, he may appeal before this one. So, ombudsman, that is why. Huh?
Complainant has not prepared any appeal.
You don't know.
I am the licensee, I have come. Because GRF has no power and jurisdiction to entertain this type of.
Who are you? Who is the complainant here?
Your complainant is this OP number 1 before your lordship now.
Who are
He is
you?
executive engineer.
I am
He
the
is executive
licensee.
license.
Oh, sure.
But in so far as you are concerned, this is an interim order. No final order is passed.
No, it is final order.
No. Only document is to be produced.
Yes, document I am, my lord, that this is circular, GRF has said that if this circular you will produce and convening the complainant that the line was drawn much before passing of this order. This thing was directed. And that we have communicated on 29/4/2025 to the complainant. This is
How the question is that one complainant filed the case and the case was disposed of. How this order was against you so that you are challenging by way of a writ petition?
My lord, against means on the ground of a jurisdiction, my lord. Because, my lord, it is, my lord, since we have complied the first part of the order, nothing is there to comply. Order of GRF. What liberty was given to the complainant to approach it? If he is agreed with this order, complainant can go to the.
Then it is an academic exercise for us.
And my lord. And
That's
why
more of academic exercise than.
My lord, the GRF should have entertained this type of dispute, my lord. What I say, my lord, this comes within the domain of the collector cum district magistrate.
It's all right. The order is not against you. Nothing is passed against you.
It's only
passed
produce the
against
document.
କହିଲେ ଯଦି ଏଇଟା ନବଦବ ତାଙ୍କୁ ଟାଇମ ଲିମିଟ ଭିତରେ ତାହେଲେ ତମେ ସେ
ଆପଣ ପରା କହୁଛନ୍ତି already ଦେଇ ସାରିଲେଣି ଆଉ ପୁଣି ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ପୁଣି କଣ?
We'll
ଆପଣ
keep
ଅଧିକ-
the legal issue open and dispose it.
No, so far the judicial aspect is concerned.
We will keep it open in the right.
Like on the writ petition has
We'll
been
keep it
filed
open.
by the petitioner executive engineer so and so.
Your lordship,
Challenging the
this we have communicated the.
All right, the order dated 8/8/2024 passed in so and so by the so and so under annexure 5. It seems that on the basis of the complaint received from the opposite party number 1, Somendra Kumar Sethi, the impugned order was passed and the respondent who the respondent in the said case the petitioner in this writ petition was directed to produce the document as evidence to the complainant as proof that 11 kV overhead line was constructed before the passing of the order by number so and so by the commissioner from secretary to government Department of Energy within 15 days from the date of issue of the order. It is further observed that in case the respondent fails to prove the same, it would be presumed that line was constructed unauthorizedly and the petitioner shall do well to shifting of the line from the plot of the complainant free of cost to the complainant. The learned counsel for the petitioner submits that the petitioner has already produced the document before the uh,
complaint.
Commissioner come.
before the consumer redressal grievance कहाँ पाखे produce କରିବାକୁ କହିଥିଲା?
ସେଟା ସମସ୍ତଙ୍କୁ ଦେଇଛି ସେଟା ସେଣ୍ଟ୍ରାଲ ଅର୍ଡର କହୁଛି ଯେ କମ୍ପ୍ଲେନାଣ୍ଟ କୁ ଦବ to
ଆଚ୍ଛା।
produce the documents
Is
as
already
evidence
complained.
complainant to the complainant.
Has already complained.
has already complied the order. Therefore,
ସେଟା 29/4/25 ରେ ଦେଇଛି ଖାଲି
Nothing survives.
therefore, we are of the view that nothing survives now for adjudication of any dispute, है ना? Accordingly, while leaving, the Land Council for the petitioner, however, submits that the authority concerned has no jurisdiction to decide such a grievance, and therefore the order is non-est in the eye of law. However, since we are of the view, leaving the legal point open, we are of the view that since the order has been complied with, we are not inclined to pass any order in this petition, which is accordingly disposed of. Yeah,
मतलब 1/1 लक्ष्मी से 29/4 में अप्लाई करो
so the order का जो date था देखेंगे
communicated to the complainant on 29/4.
29/4/2025. Yes, next.
Item 8.
This is the order passed by the Honorable Central Administrative Tribunal, where the order of dismissal was challenged. The operating part of the order under Annexure 1, page 32. This is the operating part of the order of the tribunal. In the instant case, during the inquiry, it has been conclusively proved that the applicant had submitted a fake certificate. As per the decision of various courts, the applicant has no right in to be in the service, and since the long tenure, an inquiry being done just before retirement and will not be a ground to interfere with the same. The delay of passing the punishment order, though not appreciated, has no bearing on the conclusion of the department proceeding, since there are no procedural irregularities in the entire proceeding. This tribunal is not inclined to reflect on the matter in view of the instruction of Ohio dismiss. And this is the direction of the Supreme Court. London Tribunal has not gone through the law which has been prescribed, how the inquiry will be made, how the principal justification will be given, how the order of dismissal will pass.
You produced a fake certificate.
No, ma'am.
Got the job, and then enjoyed the service period, and you also retired. So what is the
Not
illegal?
retirement.
It is mentioned that
During pendency of the
Just
inquiry,
before retirement.
what happens? The certificate which get given, annexed to.
You have been prosecuted.
No, affair, nothing has been built. Nothing has been followed. Nothing has been followed. Barely
there is a finding that you have produced the fake certificate.
So how the fake certificate?
Just a minute.
It will be proved. It has not been proved.
Wait.
At the moment I am seeing this.
Wait.
Case 33. And that is the board's for secondary education. That is given by the board.
जो paragraph 15 रे लिखा है in the instant case during the inquiry, it has been conclusively proved that the applicant has submitted a fake
Expert inquiry.
So
No opportunity given to me.
No. Expert inquiry, suppose notice is served on you.
Nothing.
Are
Notice is that I have participated. Now, when my lord, can you see, madam? At the inquiry, there is certain procedure. That is
Where is the inquiry report?
inquiry report, my lord. There are no second focus, nothing. My lord, inquiry report is the annexure is the charge sheet. And the annexure 5 is the inquiry report.
And annexure?
5.
Let us
Annexure
come to
5,
that.
page 41.
Yes,
Page
let us
41, they have communicated to me the inquiry report under annexure 5 on 39/2009.
You come to that inquiry report.
Inquiry expert inquiry.
अरे लेखा है ମୁଁ ସେଇଥିପାଇଁ କହୁଛି it was decided to hold preliminary inquiry. Accordingly, notice was issued to all concerned to attend the preliminary inquiry. The preliminary inquiry was held as per schedule. The Niranjan Singh did not attend the hearing but sent the time petition by speed post with so and so, which was received. Basing on the medical certificate, so and so, the time was allowed. Notice was issued again to attend next preliminary date. Then you sent another letter by his cousin brother to defer it. So you
Yes, sir.
Sorry?
He says I was ill, I couldn't go and all.
Why I
electronic-
challenging the inquiry? I received the notice from the inquiry officer. I filed an application. Please communicate with such a document to me. They have not communicated.
ଆପଣ ଏଇଥିରୁ ଯାହା ଜଣା ପଡୁଛି ଆପଣ ଖାଲି ସମୟ ନେଇକି ଚାଲିଛନ୍ତି ପ୍ରଥମରେ ଗୋଟେ ତାପରେ ଦୁଇଟା ତାପରେ ଏମିତି ହେଇକି ଅଲ୍ଟିମେଟଲି
ମୋ ଡକୁମେଣ୍ଟ ଦେଲେ ମୁଁ ଯିବି କଣ ଏକ୍ସପର୍ଟ ଇନକ୍ୱାରି କଲେ ଡକୁମେଣ୍ଟ ଦେଲେ ତ ମୁଁ ଯିବି
what is those application which you sent?
Yes, application minor. Kindly see for the moment charge sheet annexure 3, page 21. That is 3 number of charges.
No, we are not on that. We are saying that after receipt of the notice, the first notice is mentioned in the order that you did not attend and send a time petition. Now you are saying that no, in that time petition, I have also sent another application that please supply me the documents. Where is that?
That is the page 39. Page 39, first annexure 4, supply of documents. Memorandum charges dated to 2012-2008. With due respect, I beg to state that I have
Which
received the
page?
memorandum charges.
Which page you are placing?
Page 38.
38.
Yes, ma'am.
Yeah.
I received your memorandum charges from 2012-2008 on 27/12/2008. I came to know from the that the said memorandum that you have proposed to hold inquiry against me on the allegation of 3 number of charges relating to submission of fake educational certificate at the time of joining of your establishment. It is necessary to know the relevant documents relating to charges which are available in your office before filing of the written statement. Therefore, you are requested kindly supply the following documents. Number 1, copy of the complaint petition relating to essay certificate, copy of the high school certificate exemption, which I have filed at the time of the joining of the establishment.
What happened on this petition?
Now, then thereafter I filed another application. I filed the written statement, page 39. Page 39 I filed some details that I have filed document you are not given, and the relevant portion of the written statement that para 2, I support such illegal allegations. 7 documents have been relied upon. The 7 documents they have relied upon, but the copy of the none have been provided to me. For such, I made a prayer in form of the application which was received by your high office on 5/1/2009. In spite of such communication as on date, no copies of a necessary document and documents relied upon.
Please come to the inquiry. Please come to the inquiry report once again. Come to the inquiry. Annexure 5 is the inquiry report.
And they have to follow the procedure.
Mr. Land Council,
Procedure is
please.
there.
Have you followed the procedure?
Yes.
Why have you not filed review, departmental review and appeal? Straight away came to the.
My lord, for that is in my case. That is the case, ma'am. My inquiry report saw me in the year 2009.
But you should have filed a review before departmental review, thereafter an appeal, which is.
My lord.
No, you have not filed. That's the finding.
My lord, kindly go through all the documents, then I will satisfy. After receiving the inquiry report, I filed an application under Annexure 6. Annexure 6 is pending.
No, in this inquiry report, there is no mention that any such application for supply of documents have been submitted by you. So
That is the rules. That is within the rules too.
please listen to us and then answer.
Yes, sir.
Now you are telling that I have submitted these 2 documents before the authority for supply of the documents. But in the inquiry report, there is nowhere anything whispered that you have made any such prayer.
But that is in a file.
अरे ठीक है रहिबे ना नहीं. Where is the documentary proof that this document which you have annexed as Annexure 4 series was submitted before the authority?
Yes, sir. फाइल
ଆପଣ କେବଳ ଟାଇପ କାଗଜଟି ଆଣିକିନି ଦଉଛନ୍ତି ଏଇଟା ହଉଛି 5/1/2009 ଏମିତି ଗୋଟେ ଚିଠି ମୁଁ ଦେଇଥିଲି ଏଇ ଚିଠିଟା ଅଥରିଟିଙ୍କୁ ଦେଇଥିଲେ କୋଉ ଦିନ ଦେଇଥିଲେ ତାଙ୍କୁ ରିସିଭ କରିଥିଲେ ତାର ପ୍ରୁଫ କାହିଁ it can be very well manufactured thereafter
No,
to create ସେଇଥିପାଇଁ ତ ଆମେ କହୁଛୁ ଯେ annexure 4 series ର ଯୋଉ documents ଆପଣ ଆପଣଙ୍କର ଅଥରିଟି କୁ ଫର ସପ୍ଲାଇ ଅଫ ଡକୁମେଣ୍ଟସ ଦେଇଛନ୍ତି ତାର ଡକୁମେଣ୍ଟାରୀ ପ୍ରୁଫ କାହିଁ ଯେ ସବମିଟ କୋଉ ଦିନ ତାକୁ ରିସିଭ କଲେ ଆପଣଙ୍କର ଅଥରିଟି ତାଙ୍କର ସିଗ୍ନେଚର କାହିଁ ତାଙ୍କର ସିଲ୍ କାହିଁ ତା କାରଣ ଇନକ୍ୱାରି ରିପୋର୍ଟରେ କିଛି ମେନସନ ହେଇନି ଆପଣ ଯୋଉ ଡକୁମେଣ୍ଟ ଦେଇଛନ୍ତି ଆପ୍ଲିକେସନ ଦଉଛନ୍ତି ଯେ ଏଇଆ ଦିଅନ୍ତୁ ତା ଦେହରେ ଅଥରିଟିଙ୍କର କିଛି ସିଲ୍ ନାହିଁ ଏଣ୍ଡୋର୍ସମେଣ୍ଟ ନାହିଁ ଡେଟ୍ ନାହିଁ କିଛି ନାହିଁ ତେଣୁ 5/1/2009 ଆପଣ ଏଇ ଡକୁମେଣ୍ଟଟା ସପ୍ଲାଇ ଅଫ ଡକୁମେଣ୍ଟ ଡେପୁଟି ଜେନେରାଲ ମ୍ୟାନେଜରଙ୍କ ପାଖରେ ଦେଇଥିଲେ ବୋଲି ପ୍ରମାଣ କଣ
ସେମାନେ ତାଙ୍କର ଯୋଉ କାଉଣ୍ଟର ଦେଲେ ସେ ଆଡମିଟ କରିଛନ୍ତି ସେଥିରେ କହୁନାହାନ୍ତି ମନା କରୁନାହାନ୍ତି
କଣଟା
ମୁଁ ଯୋଉ ଡକୁମେଣ୍ଟ ଦେଇନି ବୋଲି ସେ ମନା କରୁନାହାନ୍ତି
where is the stand taken in before the original application that you have filed such a document and the document has not been supplied to you so was the ground original application yes way application
just now just not
just
ବର୍ତ୍ତମାନ ନାହିଁ
file the let us see that way application file karibe and counter file karibe let us see that ground which you are now taking you have already taken before the central administrative tribunal and what is the reply given by the authority right
That's the one thing. Another thing,
File it first. Let us.
that goes to the root of the matter ଆପଣଙ୍କୁ ଯଦି document supply ନ କରି inquiry proceed କଲେ expertise that is itself a ground to pass that
yes
so ଆପଣ satisfy କଣ
there is another reason my lord dismissal order they have not taken up
First, this reason you satisfied. That is another reason.
I'm not received the copy.
you are appealing to file the so file the this writ petition has been filed by the petitioner Niranjan Singh challenging the order dated 16/4/2025 passed by the Land Central Administrative Tribunal Cuttack Bench in OA number 360 of 2018 in dismissing the original application which was filed for quashing the departmental proceeding dated 2012-2008 and for a direction to settle all the retirement benefits including the pension of the petitioner within a stipulated time and also to quash the order of punishment dated 21/12/2012. The London Council for the petitioner urged that the inquiry was conducted ex parte and when notice was served on the petitioner with memorandum of charges dated 2012-2008 on 27/12/2008, he submitted applications under Annexure 4 series for supply of the complaint petition relating to his HSC certificate, to also copy of the HSC certificate which he had filed at the time of joining the establishment. The London Council submits that the authorities did not supply those relevant documents and proceeded with the inquiry and passed the ex parte order against the petitioner. However, on perusal of the inquiry report, we find that there is no mention that petitioner sought for any documents before the authority at any point of time. We posed a pertinent question to the London Council for the petitioner as to whether any such ground has been taken in the original application filed before the London Central Administrative Tribunal regarding the non-supply of the documents by the authority, the London Council for the petitioner 6 times to produce the copy of the original application, so also the counter filed by the opposite parties. List this matter on Quebec.
Second week of July.
Second week of July, date given.
Item 9.
Here, this is the option purchaser matter. And
Yes.
my option has been cancelled by the bank. So page 11, annexure 1, I filed proceeding under section 17(1) before the DRT. And page 15
That order has gone against you,
in favor of me.
in favor of you. So if it has gone in favor of you, why have you come here?
Now, what happened? I filed petition for implementation of the order. There is 2 parts of order. My cancellation certificate was set aside, page 15, and bank is directed to issue sale certificate. They could not comply this time. I filed an application for compliance. And they filed, bank filed one review petition, borrower filed review petition, and the guarantor filed the review petition.
Mr. Counsel, you are challenging in this writ petition the order dated 4/3/2020, right?
No, I am not challenging my.
Then
This order supports me.
Expeditious disposal of the
The
review.
petition pending since 2000.
Where is the review petition number 3? Where is that?
But the bank has filed it.
Where is that review copy of review petition?
I have mentioned.
Mentioned, but
where
there
is the
no
order sheet?
order sheet, nothing is there. How will you know that it is pending?
And who is at fault for delaying disposal of this review petition?
I have.
You have to satisfy.
Can you get the proceeding at least? Review petition proceedings.
Review petition copy आपण पास नहीं की?
ବର୍ତ୍ତମାନ ମୋ petition
नहीं तो ବର୍ତ୍ତମାନ नहीं आपण सोमवार दिन रखिले आनी परिबे तो?
ଆଣନ୍ତୁ।
तो आणନ୍ତୁ ଏବଂ तार ऑर्डर शीट टा आणନ୍ତୁ।
order sheet.
आपण टाइम नहीं नहीं किन चलथिबे।
ନା ଆମେ time
ଆଉ ଆସିକିନି ଅନ୍ୟ ପକ୍ଷ ଉପରେ ଦୋଷ କହିବେ ଆଜ୍ଞା ସେ ଟାଇମ ନଉଛନ୍ତି ତେଣୁ
ଆମ ପରେ order ଟା ସେମାନେ appeal section 18 ରେ ଗଲେ
ସେଇଥିପାଇଁ କହୁଛୁ ରିଭ୍ୟୁ ପିଟିସନ
5 ବର୍ଷ ହେଲା review ଟି file କରି
ରିଭ୍ୟୁ ପିଟିସନ ର
ଆମେ review file କରିନୁ।
ଯିଏ
We
ବି
understand
file
it. The other side has filed a review. We want to know
Sir,
the
order
delay is attributable to
Sir,
you
order sheet-
or delay is attributable to the other side.
order sheet copy ଟା ଦେଇଦେବି review
ହଁ
ଟା।
ସେଇଆ କଣ କେବେ ଦେବେ କଣ
Sir, 1 week after.
ହଁ ସେଇଆ କହୁନାହାନ୍ତି ଦେଖନ୍ତୁ the prayer in this writ petition is for a direction to the Debts Recovery Tribunal Cuttack to dispose of review petition number 3 of 2020 at an earliest stop. The London Council for the petitioner seeks some time to produce the review petition copy, so also the entire order sheet
Right.
of the said review petition.
Right.
6 1 week time for them to list this matter. 30 तारीख रे रखले हबो ना उठम
ତାପରେ
तापर week रे 7 तारीख 7th of July 2025. Yes,
item 4 is connected.
7th July 2025. Item 4.
ଆଜ୍ଞା।
Oh, 19 से तुम्हारा।
अच्छा, so এটা পরা কইলে connected with item number 19 बोली 9 बोली कइले। अच्छा भूल हम 19
item 4
item 4 रे कौन चाहूचंदी?
my fair matter. Page 33 kind of page 33. I have OP number 9 in the Lara petition, that is 135 of 2021. Page 33, man. Order dated 14/12/23. In that proceeding,
This writ petition has been filed. What prayer you?
my fair challenging order dated 14/12/23.
Okay.
Now here, matter, in my absence, my petition for stay has been rejected.
14/12/2020,
Page 30,
page 9,
page 33, man.
33, just a minute. 14/12/2033, please, 23, please place that order.
Learned AGP for petition is present. Learned counsel for opinion or 11 file Hajira. Learned counsel for opinion or 181D is present. File legal certificate of receipt opinion 1 along with a memo. The counsel for opinion 2 and opinion 3 to 8 and opinion 10 file respective time petition on the grounds stated therein. As the petition of time is allowed, no steps is taken by the other office. The case is posted for hearing of the petition dated 4/5/23, filed by OP number 9 to stay further proceeding. No step is taken by OP number 9, then the petition is dismissed. My petition
You are the opposite party number 9.
9. So only I may be permitted to file record petition there. I have challenged this one.
You have not pressed the application.
Agree.
You have not.
30 days topic gala to reach the fact. Within 30 days recall kariya.
And who stops you? You can move a fresh application. You have not pressed that application.
I am not.
Wants to file a number application with
Just tape,
তারপর লেখা হয়েছে না dismiss as not pressed.
Not pressed I afford it.
not placed হবনি actually কারণ
Now no step is taken.
no step is taken, that is correct. Not placed টা ঠিক না।
Not pressed.
Application withdraw করে দিতে।
দেখুন, the writ petition has been filed by the petitioner Prashant Kumar Mohanty, challenging the order dated 14/12/2023 passed by Reliance so and so in
LA 135.
in dismissing the petition, stay petition filed by the petitioner, who is opposite party number 9 in the said proceeding, as not pressed. Stop. The learned counsel for the petitioner submits that a petition for stay of further proceeding dated 4/5/2023 was filed by the petitioner, and when the matter was taken up on 14/12/2023, due to some difficulties, could not be no step could be taken by the opposite party number 9, and the main case was urgent to 19/1/2024 for filing the objections, if any, and for hearing, and without adjourning the stay petition to that date, the petition was dismissed as not pressed. The land counsel for the petitioner submits that he intends to file an application before the concerned authority to recall the order of dismissal of the petition, and liberty may be granted to the petitioner. In view of the limited nature of grievance of the petitioner, after hearing the learned counsel for the nobody is present, we think it proper to dispose of the writ petition, directing, permitting, giving liberty to the petitioner to move an application for recall of the impugned order dated 14/12/2023, and for press consideration of the petition dated 4/5/2023 filed by the petitioner in accordance with law. Stop. It is made clear that we have not expressed any opinion on the merits of the application. Accordingly, the writ petition is disposed of. Yes, next.
Item 10.
Item 10, Your Lordship, we have filed a caveat petition number 205 of 2023. Just now we have received the copy, my lord, of the brief. The small
What is the caveat petition number?
205 of
Please
2020.
write it down, please. Slip रे लिखी दियंतु. Our council ना मध्य आपनकर लिखी दियंतु.
Yes, sir.
To also submits that he has filed the caveat petition, and today he has received the copy of the writ petition from the Learned Council for the petitioner, and the matter may be taken up. केबे चाहुचंती?
Another one submission, my lord. Kindly have a glance to Annex 3, my lord, page
So
52.
council, we are bringing this matter with the caveat petition, and we want that whether you will take up this matter next week or you want it on
3
another
weeks
day.
after.
If you
3 weeks after.
3 weeks after. But there may be some objection from the side of the petitioner, Union of India.
Madam, kindly see page 52, Your Lordship is the counsel for the Honorable Press Court by Lord. Page 52, kindly see, my lord, in the page 52, my lord, in my writ petition.
Item 10, huh? Page 52.
No, 52, before the Honorable, so, Your Lordship, last line,
Oh, I was there.
he was the,
I was there.
All right,
Has to be listed for some other.
yes, sir.
this matter before some other bench in which one of us, Honorable Justice, Mishra is not a party.
This matter is still pending.
There are so many landlords.
You make a bit of some other bench. Yes.
Item 11.
Challenging the order of the administrative tribunal court of
Even though the government of India is not serve a copy, but the main contesting for the RSP, still then a copy will record to be served. It should not been served on us.
Union of India is a party.
They didn't have a copy.
Have you not solved the copy?
Sale is the.
No, you have added Union of India as a party through its managing director.
It cannot be. Either this Union of India will depend to the secretary or the sale will depend to the CMD or any of the authority.
You are not appearing for sale.
We are not appearing for that. If Union of India party, then we will appear for sale.
Confusing कर दी चंदी.
Then either he would delete this corrected test item.
Copy of the.
But Union of India can return to his level. Anyhow, you serve the copy.
Sale is the.
Sale different. अपन लेखिकन जो type Union of India represented through
Still authority of India is
director.
incorrect. Yes.
It should be through secretary.
Secretary, yes.
The Learning Council for the Mr. Deputy Solicitor General, Mr. Pari is present and submits that since Union of India has been arrayed as opposite party number 1, let a copy of the writ petition be served on him. The Land Council for the petition submits that he will supply the copy of the writ petition to the Land Council for the Union of India by Monday. By Monday. So let it come next week, Mr. Pari.
Yes, yes, next week.
तारीख तो देखूं तो सही जो नेक्स्ट वीक रहा 25-26 भीतर होगा यस.
Item 12.
Mr. Das.
Yes, Subhaga is there.
My lord, I am challenging the order under Annex 8. Page 37, passed by the London Central Administrative Tribunal, Kotak by Kotak. I'll come to the page 45.
45 is the operative portion of the order.
Yes, my lord.
Yeah.
Last paragraph 7. For the discussion made above, we declare that the ground based on which the further process of the case, the applicant of the result of the written test of the PET
as has been done in other cases, is stopped as illegal and accurately per the order of rejection of his candidature by his letter dated such and such. Consequently, the respondent are hereby directed to take further steps as per the rules for final selection and appointment of the applicant, as has been done in case of other selected candidates, within a period of 120 days from the date of receipt of the copy of this order. The brief of the fact is that, my lord, the petitioner floated an advertisement on 28/10/2006 inviting his application for junior trackman and helpers. The last date of the candidate closing date on 7/12/2006. The opposite party applied for the post of the trackman and helper under Annex 2, page 45. Well, come to the last slide. Signature column.
Annex 2.
Annex 2, page 25, my lord.
कौन है?
His name is Suresh Kumar Kalot. Only he signed Suresh Kumar. My lord, as per his advertisement, page 21, those are the invalid application without signature in this box provided below this page.
Who could application no?
Page 21, my lord.
21 को paragraph.
Para 15, invalid application.
Phone.
12, my lord. XII.
Double I.
I.
Just a minute.
Application without signature in the box provided below this page for poster photograph, that is summarily rejected. And come to the page 18, my lord. Signature of the applicant must be full in a running hand. Signature in capital letters will not be accepted.
Koda.
Page 18. Page 18, para VI. Roman VI.
Para 18.
नहीं, page 18.
हाँ.
Roman VI.
Signature
of the applicant must be full and running hand. Signature in capital letters will not be accepted.
अच्छा.
The opposite party signed his name only Suresh Kumar, not Suresh Kumar Kalot. Full signature is not done.
Is there any provision of giving an opportunity to correct?
No. If the application is not correctly addressed, that will be summarily rejected. My lord, come to the page 3, Annex 3. On 24/7/2013, the petitioner rejected the candidature. Para 4. As per para 15 of the employment notification, application with the above deficiencies are liable to be rejected. Therefore, your candidature for recruitment against the post of employment notification is being cancelled. You are being given opportunity to explain in writing as to why your candidature should not be cancelled. This letter was sent to the opposite party on 24/7/2012. After receipt of this letter under Annex 4, the opposite party.
No. The जोटा अपन प्लेस कले वर्तमान
Annex 3, my lord.
Annex 3 रे जो रिजेक्शन कले
आज्ञा.
The following deficiencies were noticed. अपन slash कराइची. Application is unsigned. It is not unsigned. Application is with signature that are not
in running script.
Running. এটা भी नहीं.
Signature not in Hindi or English.
এটা भी नहीं.
Sign in capital letter.
এটা भी नहीं.
Signature drastically different and different
places. এটা भी नहीं. अपन who do deficiencies केमती लिखिले? These are the deficiencies.
Para 4, my lord. As per para 15 of the employment notification, application with the
above deficiencies are liable to be rejected.
ନାଇଁ ନାଇଁ ଠିକ ଅଛି ଏ ପାରାଗ୍ରାଫ 15 ରେ କହୁଛନ୍ତି ଯଦି ଏଇ ଡିଫେକ୍ଟ ଗୁଡାକ ସିଗ୍ନେଚର ରେ ଥିବ
ଆଜ୍ଞା
ତାହେଲେ ସେ ଆପ୍ଲିକେସନ ଟାକୁ ଆପଣ ରିଜେକ୍ଟ କରିଦେବେ।
ମାନେ
ଆପଣ ବର୍ତ୍ତମାନ ତ ଆପ୍ଲିକେସନ ଦେଲେ ଆପ୍ଲିକେସନ ଆପଣ ଗୋଟିଏ ଜିନିଷ ପଏଣ୍ଟ ଆଉଟ କରୁଛନ୍ତି ଯେ ତାର ଲାଷ୍ଟ ସରନେମ ଟା ସେ ଲେଖିନି
ଆଜ୍ଞା
ଏତିକି ତ ଆପଣ ଡିଫେକ୍ଟ ଦେଖୁଛନ୍ତି ନା
କାଲି
ତ ଆପଣଙ୍କ ପାରାଗ୍ରାଫ 15 ରେ ଅଛି ଯଦି
invalid application.
ଆପ୍ଲିକେସନ ରେ ସିଗ୍ନେଚର ରେ ଏଇ ଡିଫେକ୍ଟ ଗୁଡାକ ଥିବ
ଆଜ୍ଞା
ତାହେଲେ ସେଟାକ ସେ ଆପ୍ଲିକେସନ ରିଜେକ୍ଟ ହବ।
ମୁଁ ଆଜ୍ଞା ଟିକେ ଆଉଥରେ ପଢି ଦଉଛି ଆପଣଙ୍କୁ ଇଏ ପାଇଁ
ହୁଁ
ପାରା 15 page 21
ପାରା 15
page 21
ହୁଁ
invalid application.
ହୁଁ
Application found to be having any of the following deficiency, discrepancies or irregularities will be summarily rejected.
ହୁଁ
Application form of the citizen of India or from such persons other than those
ଏଇଟା
declared.
କୋଉଟା ଏଇ ଯୋଉ ଜିନିଷଟା କୋଉଠି ଆପ୍ଲିକେବଲ ହବ କୁହନ୍ତୁ ସେ ଏତେ କଥା କଣ ଏଇ ଯୋଉ ଆପଣ ଲେଖିଛନ୍ତି ସପୋଜ ଜଣଙ୍କର ନାଁଟା ରହିଛି ପୁରା ସେ ଲାଷ୍ଟ ସରନେମ ଟା ଦେଇନି ତାହେଲେ ସେଇଟା ଗୋଟେ ଇନଭ୍ୟାଲିଡ ଆପ୍ଲିକେସନ ହବ ବୋଲି ୟା ଦେହରେ କୋଉଠି ରହିଛି
V ଟା ଦେଖନ୍ତୁ incomplete or illegal eligible application.
ହୁଁ
V
ହୁଁ
incomplete or eligible applications. Applications not filled in blank link application with overwriting, cutting, erasing, content.
ଯୋଉଟା ସେଇଟାକୁ ପଏଣ୍ଟ ଆଉଟ କରନ୍ତୁ ସବୁଗୁଡା କଣ ପଢୁଛନ୍ତି ଆପଣ ଯୋଉ ପଏଣ୍ଟଟା ରେଜ କରୁଛନ୍ତି
X double I.
ଏକ୍ସ ଡବଲ ଆଇ
Application without signature.
ସେଟା କୋଉଟା ୱିଦାଉଟ୍ ସିଗ୍ନେଚର କଣ application without signature in the box provided below the space for pasted photograph
ଆଜ୍ଞା
ଏଟା ତ ନୁହେଁ ଆପ୍ଲିକେବଲ ନୁହେଁ
ନାଇଁ
ଆପଣ ଗୋଟେ ବର୍ତ୍ତମାନ ରେଜ କରୁଛନ୍ତି ପୁରା ଗୋଟେ ପଏଣ୍ଟ ଯେ ତାର ପୁରା ସିଗ୍ନେଚର ସାର୍ ଦେଇନଥିଲା ସରନେମ ଟା ତାକୁ କାଟି ଦେଇଥିଲା ସେଇଥିପାଇଁ ସେଇଟା ଆସିବ ଇନଭ୍ୟାଲିଡ ଆପ୍ଲିକେସନ ରେ ଆପଣ ଇନଭ୍ୟାଲିଡ ଆପ୍ଲିକେସନ ର ଡେଫିନେସନ ଟା ଯୋଉ ଅଛି ତା ଦେହରେ ଏଇ ଟାଇପ ର ସିଚୁଏସନ ରେ ଯଦି ସରନେମ ଟା ଜଣେ କାଟିଦେଲା ବା ଓମିଟ କରି ଯାଇଛି
ଆଜ୍ଞା
ସେଇଟା ଗୋଟେ ଇନଭ୍ୟାଲିଡ ଆପ୍ଲିକେସନ ଭିତରେ ଆସିବ ଏ ଜିନିଷଟା କୋଉଠି ଏଥର ଅଛି ଦେଖନ୍ତୁ ଆପଣ ମାନେ ଜେନେରାଲି ଲେଖିଛନ୍ତି ଯେ ଏଇ ଟାଇପ ର ହବା କଥା ଏଇଆ ହବା କଥା କିନ୍ତୁ ଇନଭ୍ୟାଲିଡ ଆପ୍ଲିକେସନ ତା ଦେହରୁ କହିଛନ୍ତି ଯେ ଏତିକି ଜିନିଷ ହେଲେ ସେଟା ଇନଭ୍ୟାଲିଡ ଆପ୍ଲିକେସନ ହେଇପାରିବ ଏବଂ ତାହାର ଯୋଉ ଆପ୍ଲିକେସନ ଟାକୁ ଗୋଟେ ଇନଭ୍ୟାଲିଡ ଆପ୍ଲିକେସନ ହିସାବରେ ରିଜେକ୍ଟ କଲେ on the ground that his surname is not there in the application or full name is not there ଯଦି ଗୋଟେ surname ଟା ନାହିଁ ସେଟା invalid application ଭିତରେ ଆସିବ ବୋଲି ଏଇ ଯୋଉ ଡେଫିନେସନ ଆପଣ ଦେଇଛନ୍ତି ତା ଭିତରେ କୋଉଟା ଆସୁଛି ଦେଖାନ୍ତୁ
ପାଞ୍ଚଟାରେ କହୁଛି incomplete or ineligible application.
ଆରେ incomplete application is something different ଆପଣଙ୍କର signature ଏଠି କରୁଛନ୍ତି
XB ରେ କହୁଛି application with signature that are not in running street and not in Hindi or English. XB
ଆପଣଙ୍କର ଜଣ ଜଣଙ୍କର ନାଁ ଗୁଡାକ ଥାଏ କିନ୍ତୁ ବଟ୍ ଦେୟାର ୟୁଜୁଆଲ ସିଗ୍ନେଚର ଇଜ ସମଥିଙ୍ଗ ଡିଫରେଣ୍ଟ ଦେ ଡୋଣ୍ଟ ସାଇନ୍ ଅଲ୍ ଦିସ୍ ଥିଙ୍ଗସ୍ ଜଣଙ୍କର ବଡ ବଡ ନାଁ ଥିବ ଆପଣଙ୍କର କଲମ ଥିବ ଏଡିକି ଟିକେ ନାଗୁରୁ ତାଙ୍କର ଗୋଟେ ସିଗ୍ନେଚର ଥିବ ଗୋଟେ ସ୍ପେସିଫିକ ସିଗ୍ନେଚର ସେ ସେଇ ସିଗ୍ନେଚରଟା ବା ସେଇଟା ମେନସନ କଲେ ପୁରା ନାଁଟା ସେ ଇଟ୍ ଇଜ ନଟ୍ ଦ୍ୟାଟ୍ ସେ ପୁରା ନାଁଟା ମେନସନ କରିନାହାନ୍ତି ପୁରା ନାଁଟା ଯୋଉଠି ମେନସନ ହବା କଥା ଫୁଲ ନେମ୍ ରେ ମେନସନ କରିଛନ୍ତି ଆପଣ ଯୋଉଠି ସିଗ୍ନେଚର ଦେଇଛନ୍ତି
ଆଜ୍ଞା
is it your contention that signature should also be reflect the full name otherwise it will not be a signature
my lord can you come to the annex 2 again my lord.
Now, where is the cancellation order you show us?
Annex
By which order you have cancelled the candidature? The tribunal gives a finding that you have not passed any order of that kind.
No, there are two orders passed by this Central Administrative Jaipur, my lord.
No, you come to this reasoning. You have to get over this reasoning. Para 6, para 6. This order. Get over para 6. Come to para 6. Get over this first.
Annex para 6.
Impugn order. It has a history behind it.
That being agreed by the opposite party filed an filed way number 298 of 2013 before the London Central.
Paragraph 6 टा ऊपर को
Para 6 पूरा पढ़िया दरकार नहीं, in the counter it is taken. Therefore, the tribunal is at loss to know that whether his candidature really has been cancelled by the authority competent to do so. And this is the finding, 43, page 43. Yes, page 43. There is no mention.
top
Top pardon. Page 43.
Page 43.
43, para 6 of middle ray.
Order, my lord.
Page 43.
impugned order page 43 internal page is 7 top रे पढ़ो
There is no mention that as to whether such a letter has ever been communicated to the applicant, although he has legal right to know the fate of his selection. The counter is also conspicuously silent to the above extent. Therefore, this tribunal is at loss to know as to whether his candidature has really ever been cancelled by the authority competent to do. Further, it is noticed that the employment notice, it was specifically mentioned in para 15 of that the application found to have any of the mentioned discrepancies or irregularities will be summarily rejected. But in the instant case, if the application of the applicant was found with any discrepancies or irregularities in the application or candidature, ought to have been rejected outrightly instead of allowing him to through the various rigors of the test conducted by the respondent department. Therefore, this is a great flaw found to the decision-making process of the matter. Similarly, in clause 12X of the employment notice, it has been mentioned that RRC East Coast Railway shall not be responsible for any situation arising the case any certificate, declaration submitted by the applicant being found false after verification of the time of actual appointment or later by the concerned authority. It is not the case of the respondent that any such certificate or declaration submitted by the applicant was found false after he underwent two rigorous of the written test and PT. Accordingly to the respondent, after he underwent the written test followed by the PT, the application submitted by him was found deficient in as much the application unsigned, application with the signature that are not running script. Signature not in Hindi or English, sign in capital letter, signature in drastically different at different places.
That's what my brother was asking you. This
Yes,
defense.
yes, my lord.
Ready.
application पाइले ताकू written test को allow करले
Again,
एई जो ground नौचंती जे एटा होची ओटा ये application कोन incomplete application भितरे सेटा से definition भितरे सेटा आसुनी so ट्राइब्यूनल कहले यदि आपनकर एई ग्राउंड नबार थिला ताकू टोटली अलाउ ही करनो ताते
Abruptly you could have done it.
how you could have at the outset you could have rejected it ताकू केमती से एप्लीकेशन एक्सेप्ट करले ताकू से written test
the court allowed him passness. Lifted the court received passness.
all right heard the land and counsel for the petitioner land counsel for the state आपण फाइल करछन जो केस रे टिके ये अछि सेम कहि देबे ना आ तमे समय नष्ट करछु ना the Union of India and others filed this writ petition challenging the order dated 29/2024 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack in OA number so and so. It appears that the opposite party, Suresh Kumar Talot, filed the original application with the following release. ওইটা দিয়েছেন তো original application দিয়েছেন দি
Reproduce করাইছে।
हाँ ते reproduce कराइए ताकि देखते लग जाओ
Reproduce করাইছে।
हाँ the petitioners on being noticed filed the counter affidavit and in the counter affidavit the grounds have been taken like this paragraph 2 reads. After hearing the land counsel for both the parties, the land tribunal has been pleased to hold as policy operative portion raw paragraph 6 ର relevant portions ଗୁଡାକ sir
Page 43.
page 43 ରେ ଅଛି ହେଲା the land counsel for the petitioner submitted that the application which was filed by the opposite party under Annexure 2, in the said application, the full signature of the petitioner, opposite party was not there, even though his full name has been mentioned in the appropriate column. The Lennon Council then drew the attention of this court to the notification issued by the authority for employment, and wherein in paragraph number 15, it is stated that which are the invalid applications. We posed a pertinent question to the Land Council for the petitioners that if complete signature is not there in the application, whether it would come within the definition of invalid applications as per the employment notice. He placed paragraph number 15, but we don't find any such thing that if the surname is omitted from the signature, it would be an invalid application. Moreover, from the interim order, it appears that the authorities have not only accepted the application of the opposite party, but he was allowed to undergo the rigorous of the written test and PET, and followed by PET. Therefore, it appears that there was no objection at the first instance regarding any infirmity in the application submitted by the opposite party for the post in question. Therefore, we are of the view that the view taken by the Lennon Tribunal is quite justified, and we are not inclined to interfere with the same. Accordingly, the petition being devoid of merit stands dismissed. Yes, next.
Item 13.
Item 13 also in a party, they didn't serve the copy. Let them serve. Let's take up next law.
The Land Council for the Minister of Union of India is present. That is also present now. And it is stated that copy has not been served on the Union of India. Land Council for the petitioner. Madam, what is your name? Amrita Naik. Submit that she will supply the copy of the writ petition by Monday.
Today, Your Lordship.
During course of the day to the Land Council for the Union of India. List this matter. Budhavar ki Guruvar of the yes.
Item 14.
Pass on the slip, madam. For listing mention time.
Item 14 Union of India Department is equal also as the petitioner. Annexure 1 is the improving water lordship, and the relevant portion of the improving water is only page 20 lordship.
Order is under Annexure 1.
Annexure 1 lordship. And
what was the prayer of the
prayer
Lakshmidhar Das, the opposite party, before the tribunal?
For prayer person also, kind turn to only page 57.
To regularize his
yes, for regularize.
What happened? What the tribunal said?
The relevant portion is only page 24 of my brief lordship.
No, you come to the operative portion of that order.
Reading. Page 24. Page 24.
8 number paragraph question to page 23.
Okay. Page 24. The only ground raised by the respondent for rejection of the claim of the applicant for not having the upgraded minimum qualification of matriculation or ITI pass came into effect from 1/1/2006. That is much before the initial engagement of the applicant in 1984 and conferment of temporary status in 2004. which is held to be in accordance with law in the peculiar facts and circumstances of the matter, as also law laid on by the Honorable High Court in the case of Jagu Supra, the improving orders section 15/2/17 and 12/7/19, digest to be quas, and the same are hereby quas. The respondents are directed to issue consequential order of his
କେବେର ସେ employee କେବେକାର?
Lordship. Here, Lordship, during 1984, he was orally appointed. I have given the chart with the first praise. In the year 1984,
84 ରୁ ଗୋଟେ ଲୋକକୁ ଆପଣ ରଖିଲେ ସେ ଆପଣଙ୍କୁ ସର୍ଭିସ ଦେଲା ତାକୁ ରେଗୁଲାରାଇଜ କରଲେନି ରିଟାୟାର୍ଡ ହେଇସାରିଲେଣି ସେ ଲୋକ?
ହଁ, as an
କେବେ?
Retired person, Lordship, petitioner
So pending
on attending superannuation.
हाँ, so
Because by the time I mentioned, he's around 61 years.
Jagu case ଟା rightly it is covering that उमा देवी हुए तो न ही पारे but ये जो subsequent decision ଟା ଆସିଲା ଜାଗୋରେ
Here, the only catch in this case is that, Lordship, whether the department can go beyond the principle or guideline decided by the department, that is NSR 3. And the stipulation is that if a person is going to be recognized, then he has to qualify some norms, like at least he has to be a matriculate or a ITI pass. That is lacking this person as per NSR R1 filed in the counter. I have annexed this. He is only a 9th pass person. His qualification is 9th pass. That is the fact based on the records. I have filed the counter copy also in this petition, and the relevant person is R1. That is available the qualification detail also. Page 61.
What was his post?
Post is Beldar. That is called Beldar. Something like MTS.
Is there any qualification prescribed for that post?
ଜଣେ ବେଲ ବଜେଇବ ତା ପାଇଁ ଅଷ୍ଟମ ପାସ୍ କଲାଣି ଆହୁରି ଆପଣ ଦରକାର ଅଧିକା କଣ ପିଜି କରିବ ନା?
In order to regularize him, in order to give it.
At the first principle, if the qualification prescribed for the job is something, for the purpose of regulation, you have a separate qualification.
That's lot near place of portion, Lordship, the guideline. It shows in order to regularize such a group C or group D to group C, then these are the qualifications required. And this is absent with the concerned opposite party. That is how the case is moving around.
ये group D ର ପରା?
Again.
ହଁ, group D ର ବେଲ ବଜେଇବ କଣ ତାକୁ ଗୋଟେ ଅଷ୍ଟମ ପାସ୍ କଲାଣି ନବମ ପାସ୍ କରିଛି ନା?
ନବମ ପାସ୍. Here, Lordship, can you turn to
ଆପଣଙ୍କର ଥିଲା ଯେ ବେଲ ବଜେଇବା ବାଲା କେତେ ତାର କ୍ୱାଲିଫିକେସନ କଣ ଥିବ ସେତେବେଳେ ଯେତେବେଳେ ନିଆଯାଇଥିଲା?
by that time?
ଆଉ ଅବିକା ତାପରେ subsequently ଯଦି ଆପଣ ଚେଞ୍ଜ କଲେ how it will affect him?
And that is that only for regularization.
Because
ଆପଣ ଯୋଉ criteria ଟା ଚେଞ୍ଜ କଲେ ସେ post ପାଇଁ it is definitely subsequent to the engagement of the applicant. So when the applicant was engaged at that point of time, whatever educational qualification he was having, that is suitable for that post in question, right? Subsequently, मना करूँ तो अपन 15 वर्ष परे एटाको higher qualification आनले. So on that ground, can it be denied regularization? जे नहीं and particularly लोको 84 मसियारू ये करी already ये करानी बटन किसी notional benefit बोधे से पाइबो से यही ही बोले.
When is that qualification you brought? What is that?
Well, that is Lordship, running page 70, Lordship, kindly turn.
17.
70.
Date.
Yes.
70.
That is the manual we are relying upon. We have filed it there also.
केबे आसिले?
केबे आसिला म एटा 2006 ना केबे आनथि
Again.
84 रे से चाकरी देला 2006 रे आपण आनिबे घंटी वाले वाला तो मैट्रिकुलेशन क्वालिफिकेशन ताकू सही बेसिस रे ताकू ये करिवे.
Leave it.
Are the learned counsel for the petitioners. The petitioners have filed this petition challenging the order dated 17/1/2025 passed by the Learning Central Administrative Tribunal letter against Pattab in way number 331 of 2022 in allowing the original application filed by the opposite party and directing the petitioners to issue consequential order of regularization with effect from the date of when the petition opposite party's counterpart employees were regularized within a period of 60 days from the date of receipt of the order, and the opposite party, it was further held that the opposite party shall be entitled to all consequential service benefits, and insofar as the financial benefits are concerned, the same shall be on notional basis stop. From the impugned order, it appears that the prayer of the opposite party was for regularization of his engagement as casual labor bracketed billed from 10 to 1984. And grant of temporary status from 1/11/2004. The Learning Tribunal, after considering the ratio laid down by the Honorable Supreme Court in the case of Umadevi, Lekhaiche references, once Jagu, has been pleased to hold as follows. Quote for the paragraph number 8 of in entirety. The Learning Counsel for the petitioner submitted that though when the petitioner was engaged as welder, at that point of time, he had the requisite qualification, but when subsequently in 2006, it was changed, and the person concerned should have the qualification of matriculation for his engagement as welder, and that is the reason why the petitioner of opposite party could not be regularized. We are at lots to follow the submission on the ground that when the petitioner was engaged as casual labor, since you have got the qualification as was prescribed for the post of welder, if it was the higher qualification was prescribed at a later stage, it should not have been denied of the benefit of regularization, and it seems that the Learning Tribunal has rightly relied upon the ratio laid down by the Honorable Supreme Court in case of Jago, so and so, and granted the relief. Accordingly, we find no infirmity or illegality in the impugned order, and therefore the writ petition being devoid of merit stands dismissed. Like you, Rajesh Kumar Mahapatra, Senior Panel Counsel. Na? Yes, next.
Item 15.
Item
15 also they have served. They have served this day. Next week, they are them survey copy next week. Item 15.
You are item 15, it has been filed by a private party.
Yes, sir. His private party, she's filed the petition.
Yeah.
But
Instead of Union of India, I have served a copy on state here.
Okay. The Learning Counsel for the petitioner submits that will serve the copy of the writ petition on the Learning Counsel for the Union of India by Monday.
By Monday.
By Monday.
Any day.
Next week, ना proper week. 25 की 26 25 की 26 in there.
Monday.
Item 16.
Time order the 2025. You will also issue notice to the insurance company to know that whether they have reported the order amount or not. My friend has applied for insurance company.
This thing that the award is not as before, lying is before, is from that in fact it was not lying. Have you gone through the order? What do you say?
In fact, I have verified my official record as well as court record. In fact, no amount was deposited. So your lordship may direct my to deposit the hour amount. Worth 15,000 discount.
କେବେ ଡିପୋଜିଟ୍ କରିବେ କୁହନ୍ତୁ ଆପଣ କଲା
Within 2 weeks or 4 weeks, within 4 weeks.
ଆମେ ପେଣ୍ଡିଂ ରଖୁଛୁ ମ୍ୟାଟରଟାକୁ
Within 4 weeks.
the land council appearing for the insurance company submits that the company will deposit the award amount within a period of 4 weeks. 4 weeks. Look up this matter.
Before the travel.
Before the tribunal. Before the Purata like the tribunal law, yet up to hard MSCT Balasur in MSCT number 136/139 bracket C of 1992/1991. Award amount is 1,15,000. That thibo interest thibo?
No, man.
Interest nahi. Acha. The amount awarded amount like
there. Then there was 12% there.
I don't know something. I don't know something.
ଆଚ୍ଛା ଆପଣ ନାଇଁ ମିସଅଣ୍ଡରଷ୍ଟୁଡ ଗୋଟେ ଅଲଗା ଜିନିଷ ଅର୍ଡରଟା ହେଲାଣି 27/7/1996 ସେ ଯଦି ସେ ଟଙ୍କାଟା ସେତିକିବେଳେ ଆପଣ ଦେଇଥାନ୍ତେ ସେ ଯଦି ଫିକ୍ସ ଡିପୋଜିଟ କରିଥାନ୍ତା ଏଇ ଏନଏସସି ରେ ରଖିଥିଲେ ବି କେତେ ଟଙ୍କା ହେଇଥାନ୍ତା
ତାପରେ ଏମଏ ଫାଇଲ ହେଲା ଏମଏ ପରେ ଏଚଓ ଫାଇଲ ହେଲା ଫାଇଲ ମିସଅଣ୍ଡରଷ୍ଟୁଡ
कंपनी फाइल गले ये जो फाइल गया ये तो
within 4 weeks not daily then your lordship may die within 4 weeks.
award amount to within 4 weeks.
ମାନେ ତାକୁ ଜଣେ ମରି ଯାଇଛି ଅଲରେଡି
ସେଗୁଡା ସେଠି ବୁଝିବ ଆମେ ଖାଲି କହୁଛି award amount deposit କରିଦିଅନ୍ତୁ the matter will listed 4 weeks ପରେ ରଖିଦିଅନ୍ତୁ ଗୋଟେ date. The land council for both the parties shall apprise this court on the next date about the deposit of the award amount. Hello? Yes. The name of the land council will be reflected in the first list insurance company. They don't know nada ekariyo.
Already.
କିଛି ନାହିଁ ରେ କଜ ଲିଷ୍ଟ ରେ ନାହିଁ ଦେଇ ଦିଅନ୍ତୁ
ଲେଫ୍ଟ ସାଇଡ
लेफ्ट साइड केस ତଳକୁ ରହି ଯାଇଛି
ଲେଫ୍ଟ ସାଇଡ ଅଛି ଅଲରେଡି ଲେଫ୍ଟ କର୍ନର
କୋଉଠି କଣ ପାଉନାହାନ୍ତି କଜ ଲିଷ୍ଟ ଅଛି ଆଚ୍ଛା ଆଚ୍ଛା ନାଇଁ ସେଇଟା ତ ଠିକ ଅଛି ଆମେ ଓ ଏଠି ଅଛି ଯେ ନାଇଁ ଏପଟ ସାଇଡ ରେ ନାହିଁ ତ ସେ ସାମୁଦ୍ର କରିଦେବେ ସେ ଲେଖି ଦିଅନ୍ତୁ in the cause list the name of the land council should be mentioned in the cause list in the it is right hand column appropriately yes
appropriate
yes just we are coming within 2 minutes.
Item 17.
There are large number of prayers and all, that's my notes of prayers. The only prayer that filed an email stating that the only prayer that the petitioner insists is regarding the rate of interest to be charged on the petitioner's unit, which he claims is a MSME industries.
There are as many as 8 prayers. So you are confining to which prayer? Prayer number?
6.
6.
Yes, sir.
6 is direct with order that the opposite party shall respond to the detailed calculation given by the sponsor. Kyoto confined order টা দেখছি কি হচ্ছে এটা
He did 4 and 6.
MA ଗୋଟେ ফাইল করছিলে
4 and 6.
কনফাইন করিয়াবু have you filed any application a miscellaneous application or interim application that your prayer will be confined to so and so? So what is that IA number?
One 326. 1326.
132236 acha of 2000 at Flaggy.
7.
Just a minute. কিন্তু কিছু লিখি না দি ସେମିତି କିଛି ଲେଖି ନାହାନ୍ତି ରାଦର ଆହୁରି ଗୁଡାଏ ଜିନିଷ ଲେଖିଛନ୍ତି ଆପଣ ଏଇ ପ୍ରେୟାରକୁ କନଫାଇନ୍ କରୁଛନ୍ତି ବୋଲି କେବଳ why are you not just filing a memo at least that you are confining your prayer to prayer number so and so ଏତିକି ଦେଲେ ବି ଚଳିବ ସେମିତି କିଛି ଲେଖା ହେଇନି interim application ରେ
Pass an appropriate direction that the interest to be charged opposite party in relation to the loan account.
ଏଇଟା ଯେମିତି ଜଣା ପଡୁଛି ଆଡିସନାଲ ପ୍ରେୟାର ଭଳିଆ ସେଇ ଯୋଉ ପ୍ରେୟାର ଗୁଡାକ ମେନସନ କରିଥିଲେ ସେଗୁଡାକୁ ଆପଣ ତାକୁ ପ୍ରେସ୍ କରୁନାହାନ୍ତି
ଅଛି ଏଇଟାକୁ ଏଇଥିରେ କନଫାଇନ୍ କରୁଛନ୍ତି.
We just want that just file that memo in which you just mention that you are confining the prayer only to prayer number so and so that much ଯୋଉଟା 4 ଆଉ କୋଉଟା କହୁଛନ୍ତି please continue Mr. Mohan.
The petitioner applied for a loan in the year 2005 and the first loan was sanctioned in the year 2006.
Pleadings are complete.
Pleadings are complete.
Yeah. Who is for the other side?
Initially,
They are for all respondent?
No.
How many respondents?
Bank,
Bank is the
Because in the remand order by the Honorable Supreme Court, it is said that fresh notices to be issued.
Andhra Bank nahi sabuda to Andhra Bank
Union Bank.
Union Bank substitution petition.
That's that. Yes.
All right, please continue.
Sans the details lot, you will come that initially a loan was sanctioned at the rate of your lordship might look at counter.
Page 20.
Page 20. Counter is one sanction order.
Page 14 to 50.
Page 14 to 50%. As your lordship got
14 to
internet page 14 of the counter. 14 first is this page 14. এটা হচ্ছে 8/5/2005.
Right. Letter of sanction.
Sorry. এইটা হচ্ছে ডিউ ডেটটা হচ্ছে 18/5 18/5 4 স্যার এটা না স্যাংশন ডেট 18/5/2004
Yes.
এতে at that time this act has not come into force number 2006. Then this act came into force in the year 2006. This small and
देखिए
medium
आठ देखिए जोड़ा कौन
micro, small and medium enterprise development act 2006 came into force.
Yes.
Either 2006 রে আসবার পরে after this came into force, this was in order to give certain benefits and facilities to the microfinance in the matters of investment and rate of interest plus marketing allied subject as a protected industry. Then the next sanction your lordship will kindly see page 19. This was sanctioned. It a renewal of working capital.
Yes.
Page 19 of the counter. Has your lordship got it?
Yes.
Applicable to A rating, that is BMPLR plus 2.75 equal to 13.25% interest.
এটা হচ্ছে 28/11/2006 no 2005 again
2005
this it was prior to the act
No, এটা page 19 টা 2006
no 5 na
6/12/2005
is the letter of sanction and due was
due date. This is 13.25. Then the next sanction order is page 24.
Hmm. 24 is another sanction of loan.
15.75 है ना
Interest.
डेट है ना
Sanction date होगी 29/6/2007.
by that time the act has come into
Right.
force. Then we have been writing to them that Reserve Bank rate guideline अनुसार our rate fix करा treating it as MSME industries. But they didn't listen. They went on charging till 2009. 2009 sanction is renewal pays 29. Page 29 has your also got it?
আর হচ্ছে 26/2008
Then another is 35.
35.
Here your lordship will kindly see
17/12/2009.
your lordship will kindly see interest, that column, facilities, interest,
12%.
but 12% add applicable to B plus rated MSME account. Has your lordship got it?
Yes.
Then I will take your lordship to your lordship will only keep this in mind because there are no other documents to show what was the rate of interest charged by Reserve Bank from time to time, and bank has conveniently not filed the same. And we have approached the bank several times to get the surplus, but Andhra Bank, you will see, no, they don't respond to it. Now, can you come back to the writ petition? That is page 30 of the writ application with maximum. Kindly see. That is a letter of 2008. Has your lordship got it?
Yes, sir.
May I?
This is given by the Assistant General Manager.
May I be?
Yes, yes.
This is written to us, Mila. With reference to the above, we request you to furnish the following. Regarding Sambalpur branch, Samaleshwari Ferro Metals Private Limited, request for revision in interest rate as applicable to MSME category. As per extant RBI guidelines, an enterprise engaged in the manufacture, production or preservation of goods and whose investment in plant and machinery, original cost including land and building and the terms specified in is more than rupees 5 crores, but doesn't exceed 10 crores, shall be classified as medium with the original cost as per latest audit, provisional balance sheet and details of items to be excluded as specified in notification dated such and date. Copy of the notification showing the details of item to be excluded while calculating the investment in the plant is enclosed herewith for your perusal. Please submit 3-page reference note with audited balance sheet. Then thereafter, this letter has come. This applicable rate of interest to Annex 7 of the writ application and that page 35 of the counter. Now the claim is the law that this was a reference in 2008 and prior to 2008, right from 2007, we have been hesitating to grant us.
When this act came into force?
2006.
No, date of
Notified.
notification.
Date of notification.
It shall come into force on such date as the central government may by notification appoint. Acha the date hochi 18 July 2006.
Yes.
Right.
We want.
So at least from that date, you may see it. That is a simple case, but I don't want to.
କଣ କହୁଛନ୍ତି?
ସେମାନେ କହୁଛନ୍ତି ଯେ ଏଷ୍ଟପେଲ ଯଦି ତମେ ତାଙ୍କୁ ଦେଲ କେମିତି MSME ରିଜର୍ଭ ବ୍ୟାଙ୍କ ଗାଇଡଲାଇନ ଟା କଣ will be knocked down by the principle of estoppel.
Only I mean 3 paragraphs I'm bringing from my counter affidavit. I'm bringing to my lord's kind notice.
So the grievance would be that this act was notified on 18/7/2006 and he should have be entitled to the benefit under this act from that date. But you gave that benefit on 6/1/2009. Right? So the
619 issue letter effective from financial year 2010.
Code লেখা হয়েছে না?
Last that 12%. 12%.
না effective you have কেবেটু? Not on the date of passing of the order.
ଦେଇଛନ୍ତି 2010 ଦେଇଛନ୍ତି
Or due date justicia na?
due date ଟା ହଉଛି 16/12/2010 ସେଇଠୁ ଦେଇଛନ୍ତି ଫାଷ୍ଟ ଯୋଉଟା ଆମର ଡ୍ୟୁ ହଉଛି
Due date ଟା ହଉଛି 16/12/2010
ସେଇ ଦିନଠୁ ଦେଇଛନ୍ତି 10% ନେଇଛନ୍ତି ଆଉ
ଏଇଦିନଠୁ 12% ନେଇଥିବ ନା
12%.
12%.
10 ନେଇଛନ୍ତି 12%.
ହଁ,
You want it from 2006?
2006 is your 18 July 2000.
Yes.
हाँ, ସେଇଟା 18/7 ତ 18/7/2004.
12% from the date of the notification of the act.
Prevailing rate of the NEC ଯଦି ସେମାନେ 10% ଦଉଥିବେ ଆମେ 10%, ଯଦି 14% ନଉଥିବେ 14%,
Whatever.
12% whatever it is.
But 12% is admitted.
12% is admitted. So we have requested them time and again that କୋଉ ଇଏରେ କଣ rate of interest ଦିଆହବ ସେମାନେ ଦଉନାହାନ୍ତି। ତେଣୁ ଆମେ ଗୋଟେ calculation sheet ଦେଇଛୁ କେତେ excess payment ହେଇଛି, calculating at the rate of 12%.
That is the execution part. That they can take care of. The only applicability has to be decided, execution will be done. Yes.
And for my learned senior submitted from time to time under what much of the interest we have calculated and what has been taken from the borrower, that is available to my lords under annexure A series all the sanction letter. Sanction letter lekha is 80% rate of interest accordingly the bank has charged. The annexure A series, all the documents sanction letter which he has, after going through the terms and conditions of the sanction letter, the petitioner has signed it and accepted.
Somebody is entitled,
my lord,
to get certain relief under this particular
Special act. This is a beneficiary legislation. You have to give the benefit. That's all.
If you intentionally charge at a higher rate of interest
my lord,
and deprive the person which is legitimately entitled to,
my lord,
then what about your action? You are a bank and you are to give the loan to this set of industries, and the beneficial provision is that what should be your interest rate, but you have charged at a higher rate. So therefore your action is contrary to the act, and merely because he has paid it at a higher rate in terms of, so he is right from the beginning is claiming that I am not entitled to get, I am not supposed to give that at the higher rate. Please consider my case in terms of this provision. And you considered it ultimately in 2009. But what about that particular period? And if he has given that interest,
page 30 of the writ application. There, as per extant RBI guidelines, an enterpriser engaged in the manufacturing is entitled. Then the 7 admit quarterly, that is a separate rate of interest for a SME category.
This is statutory command. See.
at a higher rate because this is the beneficial provision, and
all nationalized banks are bound by the reserve guidelines.
Madam, as per my lord's query, the lordship kindly have a glance at page 10 of my counter affidavit. The specific stand of the bank, my lord, the excess rate of interest has not been charged. But moreover, my lord's query that whether from 2000, when the act came into force 2006 to 2009, is entitled to the relief, my lord.
That much you want.
Okay. Only to that effect, your lordship kindly keep some of the data. I'll ask her, because when the counter affidavit was filed, I was not the contending counsel. After
That's the precise thing.
That is, he has now confined the prayer
my lord,
to only this much. Let us pass the order in that way.
my lord.
He is now confining. So, are you filing that memo? Please file so that he will take instruction on
yes,
that.
18 July 2006.
My lord.
On the date of notification up to this.
Till 2009.
Yes.
Though this writ petition has been filed with as many as 12 prayers, but the learned counsel for the petitioner files a memo in court today that he is confining the prayer only to prayer number
4 and 6.
IV and VI. That is quote the response. After hearing the argument advanced by the learned senior advocate, Mr. Ashok Mahanti. What is your good name, learned counsel?
Bhaskar Chandra
Mr. Bhaskar Chandra Pandal, and counsel appearing for the bank, seek some time to obtain instruction in the matter. List this matter on केबे रखियो कौन तो अपन भी
That is suitable.
7 तारीख रे रखले चलो
आगे
on 7th of July 2025. ଆପଣ ସେ ମେମୋଟାରେ ଲେଖିବେ
ଏଇ ମାସରେ ରଖିଦିଅନ୍ତୁ, ମୁଁ ସେ ଫେର ବେଞ୍ଚ ବଦଳେଇଲେ ଫେର
ସେ ତ ସମୟ ନେବେ।
ବହୁତ ଥର ହେଲାଣି, ସେ କ୍ଲାଏଣ୍ଟ ବି ଆଉ ଆସୁନି ଆଜ୍ଞା, କେତେ ଥର
Supreme Court has confined it. Supreme Court directed.
ଏଇଟା 5 ମିନିଟ ଲାଗିବ।
30 ତାରିଖ ରଖିବା 30th of June 2025. ମେମୋରି ଟିକେ ଦେଖିଦେବେ, ପ୍ରେୟାରଟା ସ୍ପେସିଫିକ ଲେଖିବେ, Roman 4 ଆଉ Roman 6 ଏଟାକୁ କନଫାଇନ୍ କରୁଛନ୍ତି ବୋଲି ସେଟାକୁ ଆକର୍ଡିଂଲି ଦେଇଦେବେ। Rest of the matter will come on Monday.
Madam,
That is custody more than 12 years, madam.
Real application.
madam, yep, wait.
Here it is, more than 12 years.
Supplemental list, item number 1.
May I please your note? Last of it, your lordship.
It was called for the conduct report. May I submit?
Indian Delta result छोड़ो, no result showcase. Surrender himself from those men. Keep from all those convict has no conviction. So nothing adverse was
Nothing
reported.
happens.
କେତେ ବର୍ଷ ହେଲାଣି ଆପଣଙ୍କର?
Near about 16
Custody
years. Gary, your lordship, more than near about 4
So almost
14 years.
16 years.
16 years.
That flag K, the custody certificate is the flag K.
बाकी surrender certificate? हाँ, it is sure. हाँ,
That is more than
16 years. Are the land council for the petition, land council for the state. The land council for the state has produced written instruction received from the superintendent, circle jail, special jail, Bonaingon, which indicates that during the period of interim bail upheld by the petitioner, there were no criminal activities have been reported against him. The written instruction is taken in record. Peruse the custody certificate of the petitioner, which shows that the petitioner is in judicial custody for more than 16 years. Considering the submission made by the land council for the respective parties, the period of detention of the petitioner in judicial custody, and since no adverse has been reported against the petitioner, and there is no likelihood of the appeal being taken up for hearing in the near future, we are inclined to release the petitioner on bail. Allowed.
This is one rare one. PW3, the daughter of the deceased were the parents of the PW3, who was then 8 years old. There may be a specific direction, the appellant on his release should not
The petitioner shall not come in contact with try to come in contact with the family members of the deceased
Yes.
and shall not indulge in any criminal activities, violation of any terms and condition of the bail condition, shall entail cancellation of bail. Yes, no.
Okay.
Mr. Nirakanta Pandalek Deva.
Item 2.
Very lots of please. Final 498 है 302 accused in custody.
How many accused persons are there?
One accused.
So why have you filed two bail applications?
No, 1072 by 17 is not press minor.
Achha, just a minute. Miss case number 1072 of 2017. There is an application for bail. The London Council for the petitioner submits that since he has already filed another bail application, right, IN number 345 of 2025, he does not want to place this miscase. Accordingly, the miscase is disposed as not placed. IN number 345 of 2025.
I number 345 25 accused in custody.
Wait.
Kindly have a glance to order dated 11/4/25.
11/4.
25, order number 10. I don't know whether it is relevant or not. My duty to point it out.
Or do you mean? No, let's wait for. Na se he je roster ranking as GS Sonila assigned so on charge in the honorable judge taking of the matter therefore would not be applicable. So if the judge is not taking of that matter, that will not be applicable. So
This is my duty only to point.
no, it's all right.
So in this case, your lordship had directed the state council to produce the conduct certificate during his release on interim.
He was released on interim bail.
Yes, madam. 21 days.
Just what was his conduct?
That is yet to come. Lordship grant me one opportunity.
So you have already sought for instruction.
I have not yet.
No. Have you not sought for any instruction?
Not.
So what was the period for which you are released on bail, interim bail?
21 days.
No. Which is that order?
Order, my lord. Order
23/3/2018.
Okay. The London Council for the State. And you have got that custody certificate.
No.
You also obtained. Submits that she may be given some time to produce the custody certificate as well as the conduct of the petitioner while on interim bail as per the order dated 23/3/2018 in which case number 5 to 9 of 2018. Is this matter commission on 7th of July 2020? Name of Sriapati Pradhan and associate member. What do you want? Sriapati Pradhan, A.K. Sahoo. Malik and Esau. That the names of each agricultural council shall not be reflected in the cause distance.
Item 3.
Lordship are directed to the conduct.
No report received on the similar condition.
The custody certificate.
I don't have the
Already was there.
Lad.
No, Lordship.
What is the Supreme Court order? 30th September 2024. There is an order. Was it a bail application?
Yes, put on.
Supreme Court is rejected.
No, not rejected. Government of the opposition rejected.
Land Council for the petition and Council for the state. The Land Council for the petitioner. The state has for the written instructions. IAC Constitution 22/1/2022, which indicates that during the interim bail period, the petitioner, there was no option of consumption petition. Bail order, now the utilization of the as has been deported and that was to stop. The written instruction taken for the custody certificate available on the provision that the petitioner is in judicial custody for more than 11 years. Considering the submission by the counsel for the respective parties, the period of detention of the petitioner in judicial custody, the conduct of the petitioner required on jail and keeping the receiver down in the case of relative or such matter. Then the petition on the particular 3 months and it is to file the surrender certificate. Here.
Item 4.
Item 4. Under the report of God. The particular consent. That's we have submitted report. One after the you also called for a conduct certificate because of release on for some time. My conduct will be outside. Please conduct no idea including the following 4 years, 4 months, actual period, 3 years, single month. Yes. You know, fire on what money I was not only not no. Granted, I was never granted.
Not in India.
No, because I wasn't following leave. I could after this bill is paid. All right. The London Council for the State has produced the instructions from ISS of the police station Puri, rated 25/5/25, which indicates that the period of parole is manifest. The report is taken on report. The London Council for Information submitted that earlier the bail application of the petition was dated on verified or dated 21st October 2020. 21st October 2020. 21st October 2022. 21st October 2020. London Council petition was in judicial custody for more than more than 30 years. Considering the submission of the Land Council for the respective party and the detention of the petitioner in separate when not inclined the petition being taken into account is the detention and given the relative case of the granted. Yes. Okay, for this. Is now in the report for the reporter is under the period of confinement. May be under discipline high restricting one was remark of the reporter against the under the report of the not involved in any other case. Because it was a line. Why do you feel?
Yes, sir. Is what in jail. Extremely attacked. So there are all the jail inmates.
They bring it up. The Land Council for the State has produced the report received from the report dated for the 14/5/2025 received from IIC Arlegri Police Station. Based Rajapati, which shows that the conduct of the petitioner inside the jail was satisfactory and no adverse remark was received reported against him and he is not involved in any case. Stop. The report is taken on record. The Land Council for the appellant's petitioner for the service that he has instruction that the petitioner is in judicial custody for more than 89 years, but he cannot say the exact period. The Land Council for the State takes some time to produce the custody certificate, put up this matter. Sorry, 30th of June 2025. Yes.
Item 6.
Then finally, in Belmont, the Honorable Court directed the opposite party to obtain expression.
What is the now? Why? Honestly, a reform. Arthritis taking care of his father, the elder one, but no paralysis cute है ये बापा paralysis.
No such person will take care of anybody.
Had the Land Council for the petitioner and Council for the State. The Land Council for the State has produced the written instruction received from IAC Mount Paul Police Station dated 18/6/2025, which indicates that the father of the petitioner is suffering from paralysis and the wife of the petitioner is suffering from arthritis. The father of the petitioner who is aged about 90 years. And there is no adequate person available to take care of the wife and children of the petitioner. The report is taken on record. Considering the submission made by the land council for the respective parties, the ground taken in the interim application, the report produced by the land council for the state will enable to release the petition on interim date for a period of 2 months from the date of release, while interim date shall not indulge in any criminal activities, violation of any terms and conditions, shall enter cancellation of bail, and the matter based after 2 months. He used to produce the surrender certificate. Yes, IA is disclosed.
Item 7.
With the consent of my non-friend mail. Offering, this is not accepted mail. Civil application matter.
Custody.
Custody matter, attended about 3 years, 6 months.
ଆଗରୁ ମେରିଟ ରିଜେକ୍ଟ ହେଇଯାଇଛି
Merit to thorough rejected.
ତାହେଲେ କେବେ ରିଜେକ୍ଟ ହେଲା? ହଁ
What's your number?
10/7/2024.
10/7/24.
ବର୍ଷେ ହେଇନି ଆଉ କଣ କରାଯିବ?
It is not that.
She stayed for some time. If it was merited, 2 pages or detailed discussion on it. We are just keeping pending with Mr. The party by the council memo. Appearance of motion from the parliament this council, the council memo is taken. The name of Mr. Tripathi will be repeated in the post land council petition so that the matter will be taken up after voice this matter. Shall show thought for the
Item 8.
Marriage of the.
Oh, marriage, 23rd marriage. Earlier marriage was fixed, it was
23rd को Death of his relative.
no, marriage was postponed.
You are the अच्छा ब्लाइंड कौन है कौन?
Your daughter.
IA number so also this is an application for interim bail on the ground of marriage of the petitioner. The land council for the state has produced written instruction received from IAC Gongapur police station, which indicates that the marriage is to be solemnized on 22/6/2025. The marriage invitation card has also been annexed to the report. The report is taken on record. Considering the submission made by the land council for the respective parties, the governments taken in the implementation, the report received produced by the land council for the state, we are inclined to release the petitioner for the full year of 45 days. Accordingly, IA is disposed of matter reached on such and such date. The land council for the petitioner shall produce the surrender certificate. Yes. You want it date?
Today only, yes. Today only it will be done.
Item 9.
Custody certificate. Unless. It is conduct by
The custody certificate, so for the conduct certificate, we didn't receive that.
And even a good and level column.
Just to get.
Out of the thing, which is
New report, 10 years, 4 months, 7 days as on date.
10 years.
10 years, 9. All right, the land council for the state has produced the custody certificate of the petitioner. It is taken on record. However, he submits that the instruction has been sought for in the instruction of the conduct of the petitioner while an interim bill, but the same is awarded and the matter may be taken up next week. Next week, if this matter. Some Italy as Nagiuchi, 26 तारीख में 26 of June 2025.
Conduct and entry report.
Antecedent also.
Conduct and entry.
Antecedent. Yeah. 26th.
Item 10.
2025.
Madam,
Sugar and Council appealing for the appellant, amicus curiae, 6 for adjournment. Case is adjourned. You get the
Yes,
your
madam.
pen drive नहीं जान तो डिस्कशन पर पेपर बुक है ये ना कौन दरकार
से एग्जीक्यूटिव असिस्टेंट देता हूं
नहीं है pendrive.
the London Council for the appellant London amicus curiae submits that though he has received the copy of the paper book but he wants to the exhibits and
statement PM.
and the constituency of these statements as well as the PM report. PM report of the exhibit is exhibit by you. So 161 statements are exhibits in the pen drive of the London amicus curiae. And you already come 30th of
Yes, sir. My enrollment number has been 550 instead of 358. In the audit of
the London Council for London amicus curiae submits that his enrollment number is the report.
Item 11.
For order dated 7/5/25, we also calls for property certificate and the acquisition of the appellant.
so for acquisition, madam, you have
Just अभी इतना तो this year लेती है फिर मन के लिए थोड़ा है मतलब ये समझ पाएं और 20 टॉपिक है समझ में ना ऐड कर दो अपडेट कर दो मतलब फाइनेंस समझ 20 टॉपिक ये से कौन सा
7 years, 7 days, 7 days.
7 year and okay so application कौन अपन ना है 302 के
I filed one IA per day. I have taken up one chapter.
अच्छा you want argument the Land Council the state has produced the custody certificate and also the report on the conduct of the no and also the criminal activity the instruction regarding criminal activity the reports are taken on record the Land amicus curiae takes some time to move the application for the this matter July
next week.
अपन 30 छोड़ दो 30 छोड़ दो
IA filed for 5 days.
एक कैसे कर लेते हैं
Item 12.
As earlier, 2 months interim bail by the High Court and order my lord. Application surrendered and
केबे केबे जाइथिले
my lord.
केबे जो बेल ले जाइथिले
My lord, this order passed my lord on 7/2024. This honorable court granted 2 months bail.
ठीक समय सरेंडर कर ले
Again, surrender certificate I also filed in time. That is I made I number 306.
now you have filed another bail application
My lord.
so what is the conduct during that interim bail period not obtained देखो I number so on so bail the Land Council for the appellant petitioner published that the petitioner was granted interim bail for a period of 2 months na
2 months.
2 months 8 weeks for them 8 weeks as per the order dated 18/7/2024 in argument 113 of 2024 after availing this time he surrendered at right time
My lord also.
the Land Council for the state takes some time to obtain instruction regarding the conduct of the petitioner while on interim bail what is the point of this this is starting with commencing from 30th of June 2025 yes please.
Item 13.
Just file the surrender certificate.
Appellant?
Has to file the surrender certificate.
ठीक है council can
Mike is my lord. And this is
what happened to your surrender certificate you have not filed
I have already filed. I have already filed.
नहीं तो रिकॉर्ड नहीं हो अच्छी देखिए surrender
What are you filing?
ये तुम पहले
वो मेल किसी ने किम की कौन पते इनकी देखी ले surrender certificate
Filing is not.
पूरी फाइल को क्या आसिन surrender certificate can you send another copy in your let us say WhatsApp पे पठाई दियंतु हमर स्टेट काउंसिल को पठाई दियंतु let him verify it if you got this certificate with you now please send in the WhatsApp of the Land and State Council, let me verify. Otherwise, you have already filed on the phone. So,
947.2. 947.2.
372.
770. 43.
The Land Council for the, you are Mr. Mahanti, no? Mr. Mahanti, Land Council. Appearing to Virtual from Sambalpur, no? Virtual High Court Sambalpur submits that the appellant petitioner are availing the interim bail period as per order dated, which order were granted interim bail? 28/2025. As per order dated 20/2/2025 in IN number 2179 of 2024 has already surrendered in the trial court and has been remanded to judicial proceedings. However, his surrender certificate copy is not available on record. The Land Council for the petitioner sent the surrender certificate copy to the Land Council for the state in WhatsApp, and the Land Council for the state takes some time to verify the same. Put up this matter.
He will send.
He will send.
Will send during course of the day, and we verify some 30th of the 40th immediately. Please show the purchase. Yes.
Item 14.
Instruction matter. Whether interim bail and under the
All these other cross nothing adverse to him. It was in.
After security is nothing.
It's obviously not na.
Appearance of the year 2022. 25 to 2020. हाँ ठीक है तो
अपन पुणी कोण जाऊन जायचे बरं आपण जो ग्राउंड ନେଇକି ଯାଇଥିଲେ ସେଇ ଗ୍ରାଉଣ୍ଡରେ ଆପଣ ପୁଣି ନେଇଛନ୍ତି ରିପିଟ୍ କରି ସେ ଗ୍ରାଉଣ୍ଡ ତ ଏବଂ ଏବେକାର କ'ଣ ସାର୍ଟିଫିକେଟ୍ ଦେଇଛନ୍ତି କେବେକାର ଏଗୁଡ଼ା ଠିକ ଅଛି ଏଗୁଡ଼ା ଭେରିଫାଇ କରିଦେଇଛନ୍ତି instruction ଥିଲା about the ଯୋଉ report verification authenticity. Mr. Nayak, the report, medical report you annexed କରିଛନ୍ତି neurosurgery ର MKCC medical college
document genuine plan.
ବର୍ତ୍ତମାନ
ଯୋଉଟା ଆଇ 1900 ପରେ ଆପଣ ପଚାର କ'ଣ ଜାଣିଛନ୍ତି ବ୍ଲାକ୍ 119 of 2025
मतलब PJ का दिखा ही
ସେ ତ କ'ଣ ପଚାର କ'ଣ
ଯେତେ କରନ୍ତୁ
ଭେରିଫାଇ କରନ୍ତୁ ଯାଇଥିବ IA number 119 of 2025 is an application for interim bail on the ground of payment of the mother of the petitioner. Medical documents support the government taken in the interim application has been annexed to the interim application. The Land Council for the state takes some time to verify the authenticity of the medical document. Alternatively, the Land Council for the state has produced the written access receipt from IAC each other police station dated 19/6/2025, which shows that during the interim period nothing adverse was reported in the petition. The police station record. Nothing for it. Release the
IA number 73/2025
double murder. They are brutally killed 2 person and also Chibhoda and 1 person man.
more than
Recently on 11/12/2024,
Prisoner's petition has been received regarding engagement of Mr. Vasudev Pujari.
with SAS station sorry कर रहे मैं लाने से meeting item 111
95 year
এটা 1/11/2024 সেটা রাহুল
ମାନେ ଆଗରୁ ରିଜେକ୍ଟ ହେଇଛି ମେରିଟ ରେ
reject ହେଇଛି 11 ଆଉ partially on 11/12/2024
in view of the eyewitnesses account of 1, 2, 3, 5, 6 evidence of the doctors 16 and 17 included on ground report.
wife is suffering from cancer
Sunita Sahoo original have disorder of cancer visit
I who ground in
disorder
And it's major document. And what is your government of Mishra? Government of Mishra, the mother has happened in the department.
ସେଲ୍ଫ ଅବଜରଭେସନ ବାପ ପୁଅ ଚାରିଜଣ
ବାପ ପୁଅ ମାରିଦେଲେ ମା ସେ କରୁଥିଲା ତା ହାତ ଗୋଟେ 6 ସ୍ପଟ ପଡେ ଆଉ ଗୋଟେ ଅଧା ପଡିଥିଲା ସେ ତାର କାମ ନଥିବ ଆଉ ଫଙ୍କସନ କରୁନି
Criminal antecedent କଣ?
କ୍ରିମିନାଲ ଆକ୍ସିଡେଣ୍ଟ ମରା
ନୋ କ୍ରିମିନାଲ
The Land Council IN number consultation application for entry in the Land Council for the state has produced the report dated 9/6/2025 from IAC Patapur Police Station. In that respect, which is taken on record. The Land Council for the state submits that it's a case of double murder, and apart from that, there has been an amputation of hand of one of the witness who is related to both the deceased, and therefore he may be given some time doctor instructions regarding the criminal antecedents, if any, against the patient. For this matter, the research now.
Like the same, CCL 95 or 20%. I will provide a paper. Can I have a copy of the letter?
Have you filed your Kaladam?
I told you to have.
So we are giving you time to produce the to file the Kaladam.
I mean, a copy of the letter. Otherwise, I cannot provide.
Obviously, prisoner's petition has been received from jail regarding indictment of Mr. Vasudev Pujari as the advocate. In place of the earlier in this council, Mr. Pujari submits that the copy of the prisoner's petition will be handed over to him so that he will take instruction from the appellant and file the Kaladam. Let the registry supply the copy of the prisoner's petition to Mr. Pujari. Accordingly, the matter may be taken up. It is taken out in a single document available. Actually, then the document.
Yes,
It will be compensated by the.
already correct.
I can put it in. Document. What is it? Sure, document. So, just fill it off and file. Sorry, let the practice to prisoner's petition be sufficient. The Wakalatnama has also been sent to Mr. Pujari's permission to flag the Wakalatnama. Permission is granted. Stop. He submits that a copy of the paperwork may also be supplied to him. Let a copy of the paperwork be supplied. This one, so that's all.
As for my losses last year, I tried to
You are supposed to know that.
and for the Saturday 124, I want to
There is no interim application in the application. Apply from the Tassi Watasa. अरे आप फाइल तो ऐसे मौके में नहीं आपको कहीं आपको फाइल करेंगे तो ये बटन पेपर बुक रेडी रेडी पेपर बुक अभी व्हाट पेपर बुक अभी बताइए जुडिशियल ऑर्डर टू मैटर इन लिस्ट हां देखिए ये रन मिस्टर राउत सबमिट्स दैट ए कॉपी ऑफ द पेपर में बी सप्लाइड टोटली गिवन पेपर गोटे जजमेंट हो जासी तो कॉपी ऑफ द पेपर लेट कॉपी ऑफ द पेपर बी सप्लाइड सो ये केवल ऑर्डर लेके दे है ना दैट विल कवर 137 आल्सो
yes and 137 criminal index report is that the addition more than 70 years old
right
as a plan B
the
verification report of
secondary assunto जो GCR number 137
That be, yeah. Then I'm not reporting again on the permanent level of the my that's the special. So 2 years. 2 years.
Yeah. This is the format अच्छी जो क्वेश्चन ना 70 years but ordinary no it ତାର ସ୍ୱତନ୍ତ୍ର ଫର୍ମାଟ ଅଛି ସେମାନେ ଫିଲ୍ କରିକି ଇଏ କରିକି ଯୋଉଟା ଆପ୍ଲିକେବଲ ଠିକ୍ ମାନେ ପଠେଇ DLS ସେକ୍ରେଟାରୀ ମାନେ ମଧ୍ୟ ଯାଆନ୍ତି ତାକୁ ଇନଷ୍ଟ୍ରକ୍ସନ ଅଛି ଯେ ସେଟା ସେଇ ତାଙ୍କୁ କୁହନ୍ତୁ ଇନଷ୍ଟ୍ରକ୍ସନ ପଠେଇ ଦିଅନ୍ତୁ ଏ ଫର୍ମାଟରେ ଫାଇଲ୍ କରିଦିଅନ୍ତୁ ନାଲସାର ଗାଇଡଲାଇନ ଅନୁଯାୟୀ ସେଇ ପର୍ଟିକୁଲାର ଫର୍ମାଟରେ ସେଟା ଆସିଲା ପରେ ହାଇକୋର୍ଟ ସର୍ଭିସେସ୍ ସମିତି ଆସେ ସେ କାଉନ୍ସିଲ ଏମିସନ ଯୋଉଟା ପେସେଣ୍ଟ ବହୁତ ଜିନିଷ ରହିଛି ଯୋଉଟା ଉଲ୍ଲେଖ କରିବା ପରେ ଏଥିରୁ କି ଜଣା ପଡ଼ିଯାଉଛି ଆପଣ କୁହନ୍ତୁ ଯଦି ଟର୍ମିନାଲ ଇଲନେସ୍ କଥା ହେଉଛି ତାର ପ୍ରପର ଫର୍ମାଟରେ ଇଏ କରିବା ହେଲା এই ফরম্যাট ହିଁ ଆସେ ମୁଁ ସେମାନେ ଟେଷ୍ଟ କରନ୍ତି ଆପଣଙ୍କୁ ତାର କପି ଦେଇଦେବେ ସେମାନେ ଠିକ୍ ଅଛି ଆମର ହାଇକୋର୍ଟ ଲିଗାଲ ସର୍ଭିସେସ୍ ଅଥରିଟି କପି ପାଇଯିବେ the Land Council for the appellant submits that it appears that the petitioner is from the documents at Part B that the petitioner is suffering from coronary artery diseases and therefore he may be released on bail. But and he has to instruct the appellant to apply for bail in the prescribed format
ଯେମିତି ଆସିବ ଏଇଟା ଆସିବ ଫର୍ମାଟ ସବୁ ଯିଏ ଅଛି ସେଟା ଫର୍ମାଟ ନାଁକୁ ଆରମ୍ଭ କରି କ'ଣ ଇଏ ସବୁ ଜିନିଷ 3 ପେଜ ଗୋଟେ ଡକ୍ୟୁମେଣ୍ଟରେ ଆଉ ସାଇନ୍ କରି ଭେରିଫାଇ କରି ପଠାନ୍ତି ହେଲା ସେଇଥିରେ ବେଲ୍ ଆପ୍ଲାଏ କରିବ ବୋଲି ଆନ୍ସର ଗାଇଡଲାଇନ୍ ଫର୍ମାଟ ଆମର ବହୁତ ଫେସିଲ୍ ଆସେ ଅଛି କପି ଗୋଟେ ଫର୍ମାଟ ଲୋକ କ'ଣ ଆସେ ଏଇ ବାড়িতে ফরম্যাটটা তা দেখুন তার কেতে কলম লেখা আছে এটা দেখেই নিতে এটা নিয়ে ফটো তার ফটো নিয়ে যাবো এটা 3-4 পেজের বিভিন্ন ইস্যু লেখা আছে সেই অনুযায়ী আপ্লাই করিব ଥିଲା 70 years and above and terminal illness ହେଲା ଆଉ ଏଇଟାକୁ ଦେଖିଲେ ଆପଣ ଏଇ ଯୋଉ କାର୍ଡିଓଲୋଜିକାଲ ପ୍ରୋବ୍ଲେମଟା ସେଟା ଆସୁଛି କି ନାହିଁ ସେ ଟର୍ମିନାଲ ଇଲନେସ ଡେଫିନେସନ ବି ସେଟା ବି ଦେଖିବେ ଟର୍ମିନାଲ ଇଲନେସ କାହାକୁ କୁହାଯିବ କ୍ୟାନ୍ସର ଏଟା ଟର୍ମିନାଲ ଇଏ ତେଣୁ ସେଇଥିରେ ହିଁ ଆପଣ ପାଇବେ ତେଣୁ ଏଇଟା ସେ କାର୍ଡିଓଲୋଜିକାଲ ପ୍ରୋବ୍ଲେମଟା ଆସୁଛି କି ନାହିଁ ସେଟାକୁ ଦେଖିବେ ହେଲା ଏକ୍ସାମିନ କରନ୍ତୁ Anyone is reading this? 16.
Well-being report.
My name is there, I'm ready.
Oh, चिता होना तो चाहिए.
Well-being reports us.
हाँ कौन बात नहीं?
Well-being report us. Whether he is alive.
well-being report ଆସିବ ନା ଏଗୁଡ଼ା ସବୁ
वो ये पुराना मैटर होता है बड़ा.
ମଗା ହେଇଥିଲା ସବୁ
अच्छा ठीक अच्छा यार
ଆଣ୍ଟି କୋଉ ରିପୋର୍ଟ ଅଛି ଆମର
पूरा समूह का टाइम देंगे. सीरियली करी कह जाओ 16 8 जन हो.
16
अच्छा लिखी देवे 16 लिखी देवे the land and council for the state submits that as for the order date sponsor is yet to receive the well-being report ना no मैडम ने कहना तो सब कर दे 7 2024 आप मिनिस्टर नहीं हमें जाऊं तो पहुंचे दिल्ली जाएंगे इधर साथ में कंप्यूटर just a minute. Prematurely being able to please. Order clearly. Within report of inquiry happening. Written instruction will reach or produce or whether our form if the applicant is alive or dead, if dead please furnish the death certificate. कौन लिख ले? किसी लिख ले? वो सीट पे बदल देना. ये जो रिपोर्ट है. वो ले लिस्ट ऑफ बिल नो. आपको वो दिखाई whether the applicant is alive or dead, if dead please furnish the death certificate. ये आप इसे statement 5.6.
very well properly
Next. हाँ, copy of the paper will be supplied to the land council for the check. ना? जो इधर वाला सब करेंगे. 7/7/2020. Next.
17.
Status of the report of applicant number 1.
So regular in the year 2021, I think the request from that there are all the reasons that but so far the status is not received.
So as per the audited not this shall not be for someone alone. So you will for the time out. It will be solved. Next what is it? Some people like 133 now premature release 90 premature release अच्छा बस तभी तक नहीं होगा बड़ी काउंसिल गुड कंडीशन
needs to be done now
क्या लिखा है prematurely release to government
से देश से दिला को रिलीज बिल को रिलीज
नहीं नहीं सीट में
देश से दिला लिख से नॉट रिलीज
हां लेकिन प्रीमियम सही ठीक है पूरी जगह Mr. Naik, ये आशुन ना चेंज करिए क्या कौन? आइटम हाँ,
ठीक है सब
18.
सर जो
दूसरा कंसर्ट विजय कुमार बेरा डियर मापर तीनों आज.
दूसरा कंसर्ट बिहार.
सब डिटेल आपने सुना नहीं हो. ना हम देखा नहीं तो कार्बन गैस वाले इंस्ट्रूमेंट बदल दियो.
ये कौन है
नो दिलाने कम.
अंडरस्टैंड जो मेरा कुछ बहुत देर से जो मेरा चीज़ तो लेके सो गई ये डिटेल में ये ना डिटेल में
बार को चलो कम्युनिकेशन इतना जे आपण लिस्ट दिउन की नहीं हां आदि दे ते एप्लीकेशन ताऊ देचंती समस्त क्रिमिनल प्रैक्टिस करछंती पर लिखि देई पठाइतला आपके माने ये कोटुन वेरीफाई करी दवा पाई हां ये पुलिस बोर्ड लगे नहीं ताऊ
डिटेल में कोन एंटी तो एंटी हां डिटेल में पता हां अस्पताल
देखो the land council for the state has produced the written instruction received from IAC Arudeg Information for the dated 23/4/2025 when the mention of the petition has not been released prematurely and is now alive. So the report is taken on the phone. None appeals for the applicant state submits. Go to Uttarakhand video madhya na victim and Mahatma Naraj submits that he will intimate the land counsel for the appellant to remain present next week. What will the matter? Put up this matter next week. This is statement. Next week again.
Item 19. Page 14 no bill.
Macam serius kita ni semua start sebab time.
There are
Time saat.
item 20.
Item 20 ada contain instructions. The content for the applicant has to tell. Maka kita dapat nomor. Say you family list available. This is one of the the land council for the state has produced report. Which indicates right now. Getting the listing is in this. I see what police station before state on therefore land council for the state submits. Better Mishra Mahapatra land council was engaged earlier is not dead. So as soon as the decision by the district chief and the city girls engaged the council for the petition. I come out of the group of responses. Yes. Close prepare the sub for your continue on madam. Will be in time. One chicken is yoga. One chicken. But I don't want to be a closer line. I think 100% sure you will do one chicken. So start up there. Yes, I will. Mishra Kya? All right, that's all. Next case, report of the superintendent, Sahoo Hon'Ble. Only police look at you. Yes, I should make that. Yes, it's okay. If you watch it, recent report, yes, we have watched it. What an argument how? The next week of hearing, when either nor changes for them. Next week, we use the report, non appears for the land council for the states, submit that you will intimate. This is a super type. Again, this thing the matter next week for you. Next week. Do you like Mishra? Yes, I have a you have received the paper. Land council for the state has produced the report from so on so position that the petition of on bail and the report to taken on record Mr. Mishra and council for the appellant submit says the paper and the matter may be taken up a week after this matter from the heading of hearing. It comes in from PC. Sure, do you just watch yes. And the report. What's left? It's okay. Will be good. Upon what the command for the if the stadiums of wow. Information comes even that when it has been presented in a proper format, why are you sending partial information? You can see line council for the state as for the it also should be special level of see the recording thing which exam should be level line you know allow you sort of everything here is now ଆପଣ DG presence ଆପଣ କଥାବାର୍ତ୍ତା କରନ୍ତୁ ଏବଂ ଇସୁ ପ୍ରେଜେନ୍ସ ରେ ଇସୁ କୁ ଦେଇ ଦିଅନ୍ତୁ ଆଉ ବାକି ସିମ୍ପଲ ଡାଇରେକ୍ଟ ଜେନେରାଲ କୁ ମଧ୍ୟ ଇସୁ ଟାଇପ ମ୍ୟାଟର୍ସ ମାନେ ଆଡ୍ରେସ କରିବେ ଇନଷ୍ଟ୍ରକ୍ସନ ଦେଲେ ତମେ ଇମିଡିଏଟଲି ରେସ୍ପଣ୍ଡ କରିବ ତାର ବିଲ୍ ହବନି ହେଲା କମ୍ପ୍ଲିଟ ରିଲିଜ on how we submit that email in some time go to instruction regarding the well-being of the this is mainly coming from 7th of July 2020 this is second on yes item 26 and what about the council right the which one am the proceed yes sir the company next week also hearing is a live or taken on record council is not present when council for the state submitted will intimate the council for the plan so that might become likely for the this matter next week and we can hearing next item 27 more time more time is not sufficient item 28 more time more time next item 29 29 आवाज मांगी instruction पास है why is not present 2025 I need to be the inspection alert the applicant register mail and it's in the 2042 is left the 100 act left national house now I 6 hours more time to assist the I is mentioned that he challenged married to some other person and bottom of the election they बाकी एडवोकेट चेंज करियो ना कहिबे जानिछन रमेश महांती एस एन मिश्र बीके बेहरा 1 ए महांती वकालतनामा पुराना थी बोले
I will intimate. I am also appearing that I will introduce to Behra in the contact.
बीके बेहरा 1 लिखा है
I will intimate. My name is there. I will intimate.
स्टेट काउंसिल से इंटीमेट नेक्स्ट वीक फॉर हियरिंग जोड़ा जोड़ा नेक्स्ट वीक रही तो गार्ड कर दो ओनली मैटर लेफ्ट आउट इज आई फाइंड 22 फरीद मिश्रा कट किया कम पेपर आइटम 30 पेपर ना थी आइटम 30 नहीं
30 is fixed for hearing.
supplied with paper. Copy of the paper will be supplied to the land council for the state for the item 30. 30 रे कर देवे 30 नंबर तो मेल 30 रे पेपर बुक सप्लाई now 22 की करियो अपन करो no I you have received the copy of the paper give why paper
Rutke, you have the group?
Yes, I will.
please
So I am testing the FI first. The FI is lodged against unknown person. The accused happens to be the stepbrother of the deceased. But the accused and deceased both are residing together in official quarter. And here the FI has been lodged by one M. Gopal Rao, who is an employee of Barampur University. And the deceased was the driver of Barampur University.
please follow the FI
He is 23.
Yes, 23.
Yes,
Yes.
starts from page 21, relevant page 20.
yes
Practice to Gopalpur, Bhargav Saradhir Gopalpur, Mahasamu M. Gopal Rao,
EW
pardon
EW
yes, M. Gopal Rao, it was PW 6. Who M. Gopal Rao was Acharis, son of Balakrishna Parishar Tottvadarak, Brahmanpur Vishwavidyalaya, ଆଜି ତା 23/1/2024 ଲେଖରେ ଆପଣ ନିକଟରେ ଦେବା ଲିଖିତ ରିପୋର୍ଟ ଏହିକି ଯେ ଆଜି ସକାଳେ ମୋନାଥ ମାର୍କେଟ ନିକଟରେ ଲୋକମାନେ କଥାବାର୍ତ୍ତା ହେଉଥିବାର ଶୁଣିଲେ ଯେ ଏହି ଅଜଣା ବ୍ୟକ୍ତି ବିଶ୍ୱବିଦ୍ୟାଳୟର ଡ୍ରାଇଭର ଏଚ୍ ନାଗରାଜଙ୍କୁ ଉଡ଼ାଜାହାଜ ପଡ଼ିଆର ଶେଷ ଭାଗ ରାସ୍ତା କଡ଼ରେ ମାରି ପକାଇ ଦେଇଛି। ପରିସର ତତ୍ତ୍ୱାବଧାରକ ହିସାବରେ ମୁଁ ସାଙ୍ଗେ ସାଙ୍ଗେ ଘଟଣାସ୍ଥଳକୁ ଗଲି ଏବଂ ଦେଖିଲି H Nagaraju ଯିଏକି ବ୍ରହ୍ମପୁର ବିଶ୍ୱବିଦ୍ୟାଳୟର ମିନି ଟ୍ରକ୍ ଡ୍ରାଇଭର ଅଟେ। ଉପରୋକ୍ତ ରାସ୍ତା କଡ଼ରେ ମରି ପଡ଼ିଛି। ତା କାନ ଓ ନାକରୁ ଭୀଷଣ ରକ୍ତସ୍ରାବ ହେଉଛି ଏବଂ ଶରୀରର ଅନ୍ୟ କେତେକ ସ୍ଥାନରେ ମଧ୍ୟ କ୍ଷତ ହୋଇଛି। ମୁଁ ଅନୁମାନ କରୁଛି ଯେ ଗତ ରାତିରେ କେହି ଦୁର୍ବୃତ୍ତ ଏଚ୍ ନାଗରାଜକୁ କୌଣସି ଶକ୍ତ ବସ୍ତୁ ଦ୍ୱାରା ଆଘାତ କରି ତାକୁ ମାରି ସେଠାରେ ପକାଇ ଦେଇଛି। ଅନୁମତି କରୁଛି ଘଟଣାରେ ଯଥାଶୀଘ୍ର ଅନୁସନ୍ଧାନ କରାଯାଉ।
Witness ଅଛନ୍ତି ନା circumstances? କଣ circumstances?
Circumstances was primarily his last sin theory.
Just a minute. Let us କୋଉଠି formulate କରାହେଇଛି what are the circumstances? Trial court judgment ରେ
paragraph 16.
paragraph 16.
Page 16 of the paperwork also.
Just a minute. Page 16 paragraph
16. Page 16 paragraph 16.
ନାଇଁ ତ ସେମିତି ନାହିଁ।
On the fact that the accused with MO 11 and the deceased were lastly seen to have left their house together.
ମାନେ ଏମିତି 1 2 3 4
No,
ଦେଖି
no.
ନାହାନ୍ତି।
ନା ସେମିତି
ସେମିତି ଆଚ୍ଛା।
ସେମିତି ନାହିଁ।
All right, କୁହନ୍ତୁ ଗୋଟେ କଣ ଅଛି କହିଯାଆନ୍ତୁ। ଗୋଟେ ହଉଛି last scene,
What is last sin?
ତାପରେ
Out of seizure of wearing apparel of the deceased, I mean wearing apparel of the accused, which has not been proved.
just ନାଇଁ ଆପଣ ଆର୍ଗୁମେଣ୍ଟ କରନ୍ତୁ ଖାଲି କହିଦିଅନ୍ତୁ ମାନେ କଣ ଅଛି ତାପରେ ଆର୍ଗୁମେଣ୍ଟ ଶୁଣିବା।
Leading to discovery of the
ଲାଷ୍ଟ ସିନ୍ ହେଲା ଗୋଟେ ସିଜର ଅଫ
seizure of wearing apparels of the accused.
wearing apparel
and leading to discovery.
just a minute
27
of appellant ତାପରେ leading to discovery of
Leading to discovery of a wooden
Weapon.
weapon of wooden battery weapon of offense.
weapon of offense
wooden
Bat.
Bat, wooden bat.
bat.
Yes.
then that 18 circumstance last scene witness kiye
Last in PW 8 and 9.
PW 8 and PW 9 seizure of weapon
PW 6 and 7.
PW 6 and 7 how leading to
Doctor-
discovery
Mela?
leading to discovery
Leading to discovery PW 6 and 7. Seizure of dress re PW 5.
oh, seizure of the wearing apparel
Mela.
PW 5
Mela.
PW 5 and obviously the IO ହେଇଥିବ
Mela.
IO କେତେ ନମ୍ବର ସକି
I will tell two IOs.
ହଁ ନାଇଁ ନାଇଁ ଏଇ ଯୋଉ ଏଇ ପର୍ଟିକୁଲାର ସିଜର ଲିଷ୍ଟ ର ଆଇବ
PW 12.
PW 12
Yes, please.
so PW 5 ଆଉ PW 12 ଏମାନେ ହଉଛନ୍ତି wearing apparels of the appellant ର witness ଠିକ ତ
Yes, and it's also PW 6. PW 6.
6 ବି କହୁଛି ସେ
Yes, PW 5 and third hostile.
ଆଚ୍ଛା ନାଇଁ ସେ ହୋଷ୍ଟେଲ ସେ ପର କଥା 5 6
ଛଅ,
ଏଇ 3 ଜଣ
Right.
ବାକି ତାପରେ leading to discovery ଯୋଉ wooden bat କହୁଛନ୍ତି
6 and 7.
6 and 7
Seven.
ଆଉ ପ୍ଲସ୍ IO ହେଇଥିବ
Mela.
ସେ IO କିଏ PW 12
PW
Now- ନା
11.
PW 11 so these are the so ପଳେଇ ଆସନ୍ତୁ ଇଏ କୁ ଲାଷ୍ଟ ସିନ୍ କୁ ଆଗେ ପଳେଇ ଆସନ୍ତୁ 8 9 homicidal death not dispute
Not.
Homicidal now.
acha who is the doctor PM doctor
PW 10.
Dr. Jyoti Kumar Das. You will also get it at page 61.
PW 10 homicidal death not dispute chalo ବର୍ତ୍ତମାନ ଲାଷ୍ଟ ସିନ୍ କୁ ଆସନ୍ତୁ
Total 12 witnesses.
Mela.
8 କୁ ଆସନ୍ତୁ ଦେଖିବା ଆପଣ ଲାଷ୍ଟ ସିନ୍ ରେ କଣ କହୁଛି
PW 8 is the wife of the deceased.
of disease
H. Bhairavati. You will also get it at page 54.
just
This is Nagaraj is my husband.
yeah
I know the accused Huika Hari, present in the court. He is the younger brother of my deceased husband. On 22nd 1 2004 night.
अच्छा ये दी भाई
Yes.
Three by
Staying together.
staying together in one quarter And there is no mens rea, absolutely. It is absent.
just a minute. Younger brother of the
And step-
ताମାନେ ये
step-
होची बड़ डिसीज रोची बड़ ये होची सान ठीक तो
Step brother.
ओ निज
Step brother.
ओके ठीक है हां पढम चलो पारा 2
On 22nd 1/2004 night, occurrence took place inside the official quarter situated in the premises of university at Rongelinda. My deceased husband was working as a driver under the said university, for which he was allotted an official quarter inside the premises of the university. On the occurrence night, that is on 22nd January 2004 at about 10 p.m., my deceased husband along with the present accused went to the garage house to bring a wooden cart. The said garage house is situated inside the university campus. After half an hour, both of them brought a wooden cart by means of a mini truck to our quarter. Thereafter, they unloaded the said cart and again went, both of them, to keep the mini truck in the garage. While they went to keep the vehicle, after unloading the cart, the accused took a wooden handmade cricket bat belonging to my son along with him. When I asked the accused why he is taking the handmade wooden cricket bat, the accused told me that since during night the street dogs are creating problems, that is why he is taking. That's why he is taking. When my husband and the accused didn't return within a short period, I waited them for some time and thereafter I went to my bed. When both my husband and the accused went to keep the vehicle, they bolted the door from outside. At about 12 midnight, I heard opening of the front door of the quarter, and when I alarmed, the accused responded. When I asked about my husband, the accused told that he has not come along with him and he will come later as he was taking drink. Thereafter, the accused went to his bed and I also went to my bed. The accused's bed was at the front room of the quarter. After some time, I came to the accused and asked him why my husband has not come, even after such delay. And I requested the accused to go and to search him. Appealing, the accused went outside and after half an hour, he returned and informed me that he didn't find my husband anywhere. On the morning at about 7 a.m., I came to know from my children that my husband is lying dead on the aerodrome field at Rongeilunda, and my children heard this fact while they were going to their school. So immediately they informed me. On getting information, immediately I rushed toward the aerodrome field and I found the dead body of my husband was lying on the aerodrome field, having serious bleeding injuries on his person. I found bleeding injury on the backside of his head, right ear and right visible only eye probably. I also found several persons at the spot. Because I was examined by the police. It is not a fact that I have stated before the police that when I found the dead body of my deceased husband at the spot, I found the accused was crying sitting near the dead body. I don't remember where I have stated before the police that when my husband and accused went to keep the vehicle in the garage, at that time they bolted the door of our quarter from outside. It is not a fact that I have stated before the police that accused went to search my husband and after half an hour he returned and informed me that he didn't find him anywhere. It is not a fact that I have stated before the police that my children informed me that my husband was lying dead on the aerodrome field at Rongeilunda. It is not a fact that the accused has not gone along with my husband to keep the vehicle in the garage on the night of occurrence and that he had not taken wooden handmade cricket bat while he had been to keep the vehicle in the garage. It is not a fact that my husband had been to keep the vehicle alone on the garage being armed with wooden handmade cricket bat on the relevant night. It is not a fact since the accused is my step brother-in-law, I had borne grudge on him and that I was used to revoking him. It is not a fact that I am deposing falsehood in order to implicate the accused in the said case.
So, ଏମାନେ ରହୁଥିଲେ ୟୁନିଭର୍ସିଟିର
ଗୋଟେ
କ୍ୱାର୍ଟରରେ ସେ କୋଉ ୟୁନିଭର୍ସିଟି ସେଟା ବ୍ରହ୍ମପୁର ୟୁନିଭର୍ସିଟି ଆଚ୍ଛା ସେଠୁ ଦି ଜଣ ଯାକ ରାତି 10টাରେ ଯାଇଛନ୍ତି ଗଲା ପରେ ହଁ 10টাରେ ଗଲେ ପୁଣି ଅଧଘଣ୍ଟା ପରେ ଅର୍ଥାৎ 10:30ରେ ଫେରିଲେ ଦି ଜଣ ଯାକ
ଫଟୋ ନେଇକି ଆସିଲେ
ହଁ ଫଟୋ ନେଇ ଆସିଲେ ପୁଣି ଦି ଜଣ ଯାକ ଗଲେ
So many truck handle ତା garage ରେ ରଖିବା ପାଇଁ
ହଁ unloaded the said truck and again went both the to keep the mini truck acha mini truck କୁ garage ରେ ରଖିବାକୁ ଗଲେ ତାପରେ
ଗଲା ଗୋଟେ ବ୍ୟାଟ୍ ଟେ ଧରିକି ଗଲା accused।
ଜଣେ ଗଲା ବ୍ୟାଟ୍ ଧରିକି ତାପରେ ଇଏ ଆଉ ଫେରିଲାନି ଡିସିଜ୍ଡ ଆଉ ଫେରିନି ଆକ୍ୟୁଜ୍ଡ ଫେରିଲା ଏକୁଟିଆ ଆଉ ରାତି ସେତେବେଳେ 12ଟା ଆଚ୍ଛା ଇଏ ତାକୁ ପଚାରିଛି ଏବଂ ସେ କହିଛି ମୁଁ କିଛି ଜାଣିନି thereafter accused went to the bed and I went again I asked after some time so also asked him about the husband ତାପରେ ଦିନ ଡେଡ୍ ବଡି ମିଳିଲା ଓକେ ଏଇ ଯୋଉ ଡେଡ୍ ବଡି ମିଳିଲା ଏଠି ଆମର aerodrome field so any material what is the distance between the university quarter and the place
so far that is not so far you also can see from the spot map that is at place 78
yes
78 last place you also will see that aerostrip ରଙ୍ଗେଇଲୁଣ୍ଡା ଉଡାଜାହାଜ ପଡିଆ ଘାସ ଅବଦଳିଆ ସ୍ଥାନ ଦେନ୍ ଗୋଟେ ରୋଡ ଅଛି ଉଡାଜାହାଜ ପଡିଆ ପୂର୍ବ ପାଖ ରାସ୍ତା ତାପରେ ରାଇଟ ସାଇଡ ରୁ ହୁଡକୋ କଲୋନୀକୁ ଯାଇଥିବା ରାସ୍ତା
ନାଇଁ ନାଇଁ ଆର କ୍ୱାର୍ଟର ଟା ଦେଖେଇଛି କି ଆକ୍ୟୁଜ ର
ସେ ହୁଡକୋ କଲୋନୀ
ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ବ୍ଲକ ଡେଡ୍ ବଡି ଟା ପଡିଛି ଦେଖେଇଛି
ଡେଡ୍ ବଡି ଦେଖେଇଛି
So if there are two brothers, one is the stepbrother of the other, and both of them are going and bringing the court together in a mini truck, and then again both of them going, what is the motive behind commission of crime?
PW
Anybody has stated anything?
PW9 son of the deceased said that
so motive ବିଷୟରେ କିଏ କହୁଛି PW9
ତ ଯେ ମୋ ବାପା ଯେତେବେଳେ ମଦ ପିଅନ୍ତି
that is not motive you also can let me learn it for
ନାଇଁ ଏଇଟା ଆଗେ ସରିଯାଉ ଏଇ ଯୋଉ ଆଉ ଗୋଟେ ସାକ୍ଷୀ ରହିଲା ନା PW9 ଟା କହିଦିଅନ୍ତୁ ଲାଷ୍ଟ ସିନ୍ ଉପରେ ଆଉ ଜଣେ ସାକ୍ଷୀ ରହିଲା ଆପଣ କହୁଥିଲେ ପରା PW9 he is also the witness who has stated about the motive as you say
last in
no son of the
deceased
the minor son
of deceased just
child
what is this
was there about 14 years
14 years
okay please place the evidence
I know that I studied from page 58 years I know the accused Huikahari present in the dock is my uncle younger brother of my deceased father this is S. Nagaraju is my father. My father died on 22nd January 2004 during night. On 22nd January 2004 at about 10 p.m., my father S. Nagaraju and the accused went to the garage of the university to bring a cot. After 1 hour, both brought a cot in a mini truck to our quarter where we were staying there. After keeping the cot in the quarter, again my father and the accused went to the university garage to keep the said mini truck. And at that time, the accused took my handmade cricket bat along with him. Seeing this, myself and my mother asked the accused why he is taking my handmade cricket bat along with him. The accused told us that since they will come on foot after keeping the vehicle in the garage to save them from street dogs, the cricket bats are being used. Thereafter, myself, my mother, and my younger brother went to our bed. On the morning, my mother informed me that somebody has killed my father.
Underline this line. In the morning, my mother informed me, but mother says that it is the children who is in.
Yes. Great to lawsuit. Informed me that somebody has killed my father. Therefore, myself, my mother, and my younger brother proceeded towards the last part of the aerodrome field at Rangelunda. We found some people along with police personnel were on a portion of the said field. We rushed to the spot and found my father was lying dead, having bleeding injury all over his body. we also found the accused was sitting at distance of 10 feet away from the dead body of my father. When I asked the accused about the cause of death of my father, the accused didn't reply. Prior to the occurrence, whenever my deceased father returned to our house after taking liquor, the accused used to quarrel with him. To my knowledge, the accused has committed murder of my deceased father. This is my said handmade cricket bat, already marked as exhibit. MO.
Motive is he was drinking.
Yes.
He is not.
Whatever I drink, usually the opposite. That can be said.
That can't be.
This part which is stated by this son,
Yes.
as it appears, the mother, son, they went together to that airport or aerodrome field. But mother evidence is silence regarding the
presence of
the accused.
Yes. But son says he was very well present.
And the mother says that the children informed her.
Yes.
While they were going to the school, they heard from somewhere and came and informed her.
Yes. It is just the reverse.
That contradiction.
And so far the last scene, they going to the kindly have a glance to the page 32, 31, accused statement. Question number 10, 11 and 12.
Question number
10, 11 and 12.
Accused statement start from page 43.
Yes. Yes.
43.
No, 30. I start from
page 29.
29. Page 31, question 10.
Two questions?
10, 11 and 12.
Mishra. 10, 11, 12. What happened to that vehicle? Which
garage
no, whether anybody has seen that that was in the vehicle that in the garage. IOC ବିଷୟରେ କିଛି କହୁ କାରଣ ସେ ଏମାନେ ଗଲେ ଗୋଟେ ପର୍ଟିକୁଲାର ପର୍ପସ ରେ ପୁଣି ଯୋଉ ଗଲେ ସେକେଣ୍ଡ ଟାଇମ ଭେହିକିଲ ଟାକୁ ଗ୍ୟାରେଜ ରେ ରଖିକି ଆସିବେ
ସେ ବିଷୟରେ କିଛି ଏଭିଡେନ୍ସ ନାହିଁ ଥିଲା କି ନଥିଲା.
Let us see the corresponding injury.
Yes.
The injury is attributable to the bat. Whether
P10.
Where is doctors?
That is in the
What are the
report.
What are the injuries?
PW 10 paragraph running page 61.
Yes, para 2.
To find that the injury detected on the dead body of this launcher is possible by the seized weapon of offense. Paragraph 6 says verify, examine the weapon of offense, that is cricket bat, and that is there.
And also injuries are possible by the
No, ठीक है.
That's confusion, apparent confusion. Right.
ମଦ ପିଉଥିଲା କିଏ? ଡିସିଷ୍ଟ ପିଉଥିଲା? ଡିସିଷ୍ଟ ପିଉଥିଲା, ଇଏ ଆକ୍ୟୁଜ ତାକୁ ମନା କଲା.
He was concerned about the health of his brother. Can we check the motive?
leading to discovery, PW 6 and 7.
କଣଟା leading to?
Bat.
Bat ପୁରା ପଡିଥିଲା ତା ସାଇଡରେ
ପଡିଥିଲା ରିକଭରି
ଡେଡ ବଡି ସ୍ପଟରେ ମିଳିଲା ଆଉ ରିକଭରି କଣ ହବ? ଇଜିଲି
ଘାସ ଭିତରେ ପଶିଥିଲା ଏନେଇ ସେଟା ଦେଖିବା.
No, just a minute. ଆପଣଙ୍କର ଏଭିଡେନ୍ସ କିଏ ଦେଇଛି ଯୋଉ ସେ ବିଷୟରେ? ଆଇଓ କିଏ?
Discovery 6, 7 and 11.
11 and 12 both. Here 11 is.
11 ହଉଛି ସେ ଯୋଉ ଇଏର ସାକ୍ଷୀଟା ମାନେ आयु
बैट
बैट अच्छा I arrested अच्छा that is page number 66 last 4-5 lines after being confirmed that H Hari is the accused arrested him recorded the confessional statement while in police custody in presence of the witnesses before me as per exhibit 9 the proceeded to the BG area at a distance of 80 feet from the spot being laid by the accused while in police custody seized a handmade wooden cricket bat with the accused brought out from the bush stating to have concealed it in presence of the witnesses sponsor. Seizure list होची exhibit 8. Exhibit 8 टा देखो.
The bat was sent to CFA, sir.
Yes, I'd like to report us.
The report is there. No report.
At no opinion. No
page 75.
Blood stain is not found.
No, yes, no opinion.
Blood stain was found, but
Blood was
no opinion.
Visible fact, no opinion. Deteriorate.
But from the shirt of the accused, the blood group B, that was detected.
There, my lord, is confused. That the shirt of the accused or pen of the accused, that has not been broken. And that's the link, missing link. That you will also get it from P 5, 6 and P 12.
Wearing apparels जो appellant रो पूछन.
Appellant.
Mark H MO.
Appellant
Porter produce है जिना नहीं produce.
हाँ produce है.
कैसे कोटा You come to the forwarding report. ता जरूर जोना पड़ जियो कोटा उची तार 60 फुटा पैंट.
ये MO
it is
MO 5 and 6.
MO 6 and MO 5.
MO 5 and 6.
MO 5 and MO 6.
Wearing apparels of the deceased MO 5 and 6 has already been identified as the seizure blood stain pant and shirt of
MO 5 and 6 को कौन बाहर ला मोरो?
Plus PW 5 and 6 I'm reading. PW 5 will also be kindly see at page 43 has turned hostile Surendranath Das.
No, ठीक है जी. Chemical examination report रे
Human blood group B group. Human blood B group.
B group.
सेटा उसी मार्क कितला कितने
क्षेत्र मार्क कितला B group full shot I.
नहीं the forwarding report देखो मार्क कितला.
Forwarding report
exhibit ये जो page number 73 को पढ़ा है सुन. Forwarding report रे.
full start exhibit I.
Exhibit I just.
H I full pant H.
Page 74. 74 you want deep blue color full pant stained with blood on the leg portion having a sticker on the backside pocket written as dolphin of it was accused. H ta.
Yes.
I टा भी accused. So ये दीटा होची mark होची H and I.
Yes.
H and I रो बाहर होची हमरो ता next page रे होची report.
Yes.
H and I रे blood बाहरची human blood भी बाहरची group होची B.
B.
And which is also the blood group of
deceased.
Deceased. यहाँ पर कौन question पचरा है जी? What is the explanation? Any questions have been put on that your wearing apparels were containing the blood which was of the blood group of the deceased. Number 7. He also states that on the necklace also something called here with this also. Aside from the barber in your house where
blue color footprint, stickers, so on, so on, sky color footsteps were on the safe fence, which the police seized. The police seized pala. Then you go. So you don't pay children stated on 24 1 question. You don't pay children stated that on 24 1 2004 morning on getting information that the deceased had been murdered at 3:30 p.m. when he went to his quarter. Sanjay police have been called him, showed a sky color footstep, demo 6 and a navy blue color footprint, demo V and see the same on exhibit 5. But you say just video person what we want to know exhibit 16 होची মানে forensic science report exhibit 16 पर क्वेश्चन पचाई थी जाई था जो कैसा दिया था तादे जो ब्लॉड मिला सेट ऑफ डिसीज ब्लॉड as per the report exhibit 16 ये विषय पचाई so that is how the questions we put so that you will get a chance to explain question 18 one attention this is the question that's not so this is not no this is not the question this is question time specific questions should be done but आपको जो ये चीज जरा एटा पठाए था लाटी एटा परीक्षा ना रिपोर्ट एग्जीक्यूशन रिपोर्ट में जो आपको आपको जो ह्यूमन बॉडी वाला ग्रुप ओसी बी एवं जहां तक कुछ डिसीज ब्लड in regard to exhibit 16 there is not a single question see it is not how can we utilize it you could have explained something there making in and जहां नहीं कोई था so Mr. Naik please both of you also verify whether any questions have been put with reference to an item other point out regarding exhibit 16 finding of exhibit 16 so any of you are noting it down whether any question minor study करिएगा whether any question put on C report exhibit 16 যদি এই ফাইন্ডিংটা চাইনি তাহলে জাস্ট খালি ওটা আসি বলে আমরা তাহলে সিজি দিলাম বাস দ্যাটস অল আর যদি আপনি পছন্দ থাকে সিভিল কোয়ালিফাই করতে পারলে আমরা মারামারি করে সেই লোকাল জিমো রকম হ্যাঁ যদি কি করতে চাই তাহলে ক্যারি করতে এক্সপ্লেনেশন আপন স্কোপ যদি না দেয় হাউ টু ইউটিলাইজ দ্য সার্কামস্টেন্স এগেইনস্ট দি অ্যাকিউজ সো এই জিনিসটা যদি বাকি ব্যাক কথা পারা বাট ওদি ব্যাক অ্যাটিটিউড অফ দি অ্যাকিউজ ইট ওয়াজ রিকভার্ড ফ্রম দি বুশ এরিয়া নো ব্যাক নট নোরিয়ান বুথ এট নো সারম্বা আচ্ছা নো জি ডিক্লেরেটেড he had lost it where already जी आता मार्केट जी हिसाब से लॉर्ड लिखा है बट मुक्ति है ये मान की नहीं फिर भी कौन मुक्त लोग नो कभी डिक्लेरेट है लिखा है so say that this bat was seized and this bat can be also utilized for causing the injuries which were noticed on the person of the deceased if the evidence of the pain doctor is accepted that even a bad day might be injury that is possible so into particular bat वो आपकी लिंक करियो को दरकार का यदि ब्लड ग्रुप मिलता था तो मैंने ब्लड मिलता था तो मिलता था ओके बेच गया था बाकी मोटिव का नाम सुनती जे और भाई मतलब था सारा भाई तक आपको ही बोलता so how far this can be said to be a real motive behind the commission of the crime so यदि as Mr. Patia pointed out suppose सारा भाई माना को बड़ा ही टीम को बड़ा मानना पड़ता है so can that be a sin that will be wrong that somebody that also the that was record and POC session that the that was not checked that was statistically not and that about the that using your battery the machine with that CGC are the instance the agent that was CGC are the instance of the other and doctor says that this type of bat can cause injuries by on the disease. But again, we have to further say that whether this particular bat, which was recovered at instance of the after land, that was the paper copy, so it was just a bat recovered. So, this is an instance of the cleansing evidence. The setting in the bat recovery is number one. So, we are last in option. So, we are motive the cleansing. So, to the recovery hochi are very after us. The very after us questions here. So, 80 is the asila. How can the change something on which there will be no inescapable conclusion that it is the accused and accused error who has committed the crime. Come to page 73. Exhibit D, exhibit D and exhibit H. There are two pages. What this is? This is that is also blue. Yes. It is a part of the issue. That is the blood group of one. But questions should have been put. Who is this? No. The report shall be put. Ayo. The pictures of the accused in this scene of the occurrence. Two different stories coming up. The mother and son, both of them went to the spot where the dead body was lying. Son only stated that the accused was there, sitting at a distance. Mother is silent. So other cases also stating that it was what party was doing there? What is the conduct? Yes, yes, the brother whether he's supposed to be there. But both against the normal human conduct. It is the other time. Why would be there at all? And it's like the son of the deceased is like. What is that now? How much you are on? I don't know. No, how much you are on? High pressure. Yeah. Service. This year number 91 of 2007. One aspect is very we have signal and these are that and also like the opponent. We got the one before of and second additional sessions are down in session case number 45 of 2006 for offense municipal under section 302 of the Indian Penal Code on the accusation that the evening night of 22 to 23 January 2012 he committed murder of the deceased Mika Naraju, the after the deceased at the near end of Air Street roadside of Municipal. The Lennon High Court by judgment and court dated 31st of August 2007 found the appellant guilty However, no default sentence has been ordered for non-payment of the fine amount. Stop. PW6 A. Gopal Rao was the first information report on 23/1/2004 before the official charge of Gopalpur police station, where it stated that he came to know from some persons at Monarch Market that the body of the deceased was lying by the gas strip and somebody has committed murder to the deceased. Since PW6 was the campus supervisor of Bhanjo Bihar University, he came to the spot where the dead body was lying and found injuries on the person of the deceased. Accordingly, he lodged the report against unknown persons, basing on which Gopalpur PS case number 7 dated 23/1/2004 was registered under section 302 of the Indian Penal Code. By PW11 Kailas Chandra Acharya, the officer in charge of Swanson. After registration of the case, PW11 took up investigation of the case, examined the informant, came to the spot, conducted inquest over the dead body of the deceased in presence of the witnesses and prepared the inquest report exhibit 3 and sent the dead body to the FMT department of MKCG Medical College Hospital, Barampur for postmortem examination through the constables. PW11 also seized the Boston Earth sample earth and 2 Hawaii slippers of the deceased from the spot in presence of the witnesses under seizure list exhibit 7. He examined the family members of the deceased, other witnesses, seized the wearing apparels of the deceased on production by the escort constable at Gopalpur police station under seizure list exhibit 1. Stop. The wearing apparels of the appellant were seized as it was hanging on a wire on the backside of the rented house in presence of witnesses as per seizure list exhibit 5. The appellant was arrested and a statement under section 27 of the Evidence Act was recorded, and he led the police party and other witnesses to a bushy area which was at a distance of 80 feet from the spot where the dead body was lying, and produced a wooden cricket bat from inside the bush, which was seized as per seizure list exhibit 8. Stop. The appellant was forwarded to court on 25/1/2004. Stop. PW11 prepared the spot map by exhibit 12, and on 6/2/2004 he handed over the charge of investigation to PW12 Kishore Chandra Das, who re-examined the witnesses, revisited the spot, received the PM report of the deceased, sent the viscera of the deceased to SFSL Bhubaneswar for chemical examination, see some photographs of the scene of occurrence, produce the weapon of offense before the doctor who conducted postmortem examination and made a query regarding possibility of the injury sustained by the deceased with such weapon, and received the answer to his query by exhibit 11. And on completion of investigation, he submitted charge sheet against the appellant under section 302 of the Indian Penal Code. Next file. On submission of charge sheet, the case was committed to the Court of Session, complying the due procedure, where the London Trial Court framed charge against the appellant on 10/2/2005. The appellant refuted the charges and claimed to be tried, and accordingly, a sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined 12 witnesses, the court for you. The prosecution also exhibited 17 documents. The prosecution also proved the 23 material objects and the last one. The defense plea of the appellant is not denied. The London Trial Court, after assessing the oral as well as documentary evidence, came to hold that in view of the evidence of PWs 3, 6, 8, and 9, so the evidence of the Dr. PW 10 and his report exhibit 10, the prosecution has proved that the death of the deceased was homicide in nature. The London Trial Court, taking into account the motive behind the commission of crime as deposed by PW 9, the evidence of last scene as deposed by PW 8 and 9, the COD weapons as deposed by PW 5, 6, and 12, and the leading to consider of wearing others of the appellant as deposed by PW 5, 6, and 12, and leading to discovery of the weapon of offense that is within that as deposed by PW 6, 7, and PW 11, found the appellant guilty of the offense charge. Mr. Jamija Pakir and counsel for the appellant submitted that there is no direct evidence in the case and is based on circumstantial evidence. And the motive behind the commission of crime as deposed to by PW9 is secular in nature. He further submits that the petitioner is that the appellant and the deceased are related to each other, and the deceased was the step brother of the appellant, and he was elder brother, and the materials available on record indicate that prior to the occurrence, they had gone to bring one cot together, and they also brought it, which shows that there was good relationship between them. He argued that though the wife of the deceased being examined, the son of the deceased being examined as PW9, which is child witness, stated that when he along with his mother, PW8, visited the spot after coming to know about the death of the deceased, the appellant was found there sitting at a distance of 10 feet from the dead body of his father, but the evidence of PW8, the widow of the deceased, is completely silent in that respect. He further argued that though one pant and shirt has been seized by the investigating officer, PW 12, which is PW12, which is stated to be that of the deceased, yes, which is stated to be that of the appellant, but there is no clinching evidence that those pant that he said and of the appellant. He further argued that the wheel bat which was seized by the police, stated to be the instance of the appellant, was sent for chemical examination, and the C report indicates that the poison and the group of the blood could not be determined. As the Land Council submits that even though the FSL report indicates, the examination report indicates that human blood of group B was found in the foot and shirt of the appellant, which is stated to be the blood group of deceased, but in the 330 CRPC statement, no question has been put with respect to the C report exhibit 16, and therefore this evidence should not have been utilized against the appellant. The Land Council submits that the circumstances available on record do not form a complete chain to complete irresistible conclusion that it was the appellant who is the author of the crime, and therefore the defect case of doubt should be extended in favor of the appellant. Mr. Parthasathy Naik and S.T. Omnet, on the other hand, supported the prosecution case and stated that the two witnesses, PW8 and 9, are natural witnesses who have stated that the appellant left the house in the company of the deceased at about midnight, and on the next day morning, the dead body of the deceased was found from the helipad, and specific questions have been put on this last in circumstance to the appellant in the 313 CRPC statement, but no explanation has been offered by the appellant. The Land Council submits that the seizure of the weapon, that is the cricket bat, at the instance of the appellant from inside the bush, as per the statement of the appellant recorded under section 27 of the Evidence Act, is another factor which cannot be, which is very relevant in as much as the Dr. bracket PW team who conducted post-mortem examination also examined this bat on being produced by the IU and gave a positive opinion that the injuries detected on the body of the deceased would be possible by such weapon. The Land Council further submits that the appellant's wrists, that is one full pant and shirt, were seized from the backside of the house where it was hanging, and it was sent for chemical examination, and Exhibit 16 clearly indicates that it contains human blood of group B, which is also the blood group of the deceased, which would be evident from the report. And since the homicidal death of the death of the deceased is not in dispute, the circumstances which have been established by the prosecution can be said to be sufficient to form a complete chain, and therefore the London trial court is quite justified in accepting these circumstances and finding the appellant guilty under section 302 of the Indian Penal Code. Stop. Adverting to the contention raised by the London Council for the respective parties, at the outset, let us see that whether the prosecution has successfully established that the deceased met with homicidal death or not. Apart from the inquest report marked as Exhibit 3, the evidence of the Dr. bracket PW10, so also the postmortem report, while Exhibit 10 are very much relevant for this purpose. PW10 conducted the postmortem examination of the deceased on 23/1/2004, and he noticed in the Department of FMT MKCG Medical College Hospital, Berhampur, and he noticed the following external injuries, page number 61, paragraph number 2. On dissection, he noticed the following internal injuries, score there. The doctor has stated that the injuries were such and such, paragraph number 4. He has also proved the PM report by Exhibit 10. Though some questions have been put in the cross-examination by the London Defence Counsel, but the evidence of the doctor has remained unchallenged. After going through the evidence of the doctor and the postmortem report, we are of the view that the finding of the London trial court that the prosecution has successfully established that the deceased met a homicidal death is quite justified. In fact, there was no challenge by the London Council for the appellant to this aspect. Stop. Coming to the last scene of the appellant in the company of the deceased, two witnesses, the evidence of two witnesses are relevant, and they are PW8, the widow of the deceased, and PW9, the son of the deceased, the minor son of the deceased. PW8 has stated that on the night of occurrence, that is on 22/1/2004, at about 10 p.m., the deceased, along with the appellant, went to garage house to bring a wooden cart, and the garage house was situated inside the university campus. She further stated that after half an hour, both of them brought the wooden cart by means of a mini truck to their quarter, unloaded the same, and again both of them went together to keep the mini truck in the garage. And while leaving the house, the appellant took the wooden cricket bat which belonged to PW9, and he told PW8 that since during night the street dogs were creating problems, that is how he was taking the bat. She further stated that though she waited for some time, but neither the appellant nor the deceased returned back, and she went to bed, and at about midnight, he heard the opening of the front door of the quarter, which was bolted from outside when the appellant and the deceased left the quarters. PW8 did not find the deceased, but only the appellant had come. And when she asked the appellant regarding the whereabouts of the deceased, the appellant replied that the deceased would come at a later point of time as he was taking liquor. It is PW 8 further stated that the appellant went to his bed and she also went to her bed, and the appellant did not return in that night. And when he requested the appellant to go and search for the deceased, the appellant went outside, and after half an hour, he returned and informed her that he could not find the deceased anywhere. She stated that on the next day morning, she came to know about the dead body of the deceased husband was lying on the aerodrome field at Rongelunda, and she rushed toward the field and found the dead body lying there with bleeding injuries. The evidence of PW8, the child witness, who is the son of the deceased, and PW8 is almost identical regarding the appellant and the deceased living together after keeping the cot in the quarters, to keep the vehicle in the garage, and also the appellant carrying the cricket bat with him. Therefore, the evidence of these two witnesses, that is PW8 and PW9, proves that in the occurrence night at about 10:30, the appellant and the deceased went together after keeping the wooden cot in the quarters, and the appellant was carrying the bat of the PW9, and the appellant only returned to the quarters, but the deceased did not return, and his dead body was found on the next day with injuries in the aerodrome field. Stop. So far as the motive part is concerned, PW9, the child witness has stated that prior to the occurrence, whenever his deceased father was returning home after taking liquor, the appellant used to quarrel with him. Stop. He further stated about the presence of the appellant at a distance of about 10 feet away from the dead body of the father lying in the aerodrome field. The evidence of PW8 is completely silent on either aspect. Neither PW8 has stated that at any point of time the appellant was quarreling with the deceased over the issue of taking liquor by the deceased, nor she has stated that the appellant was present near the dead body in the aerodrome field on the next day morning, when both PW8 and both she as well as her son visited the spot. The motive which has been put forth through the evidence of PW9 cannot be that clinching, and it cannot be said that merely because the appellant was quarreling with his elder brother, bracket deceased, was taking liquor and coming to the house, can form the motive behind the commission of the crime. Therefore, we are of the view that the prosecution has failed to prove any cogent motive on the part of the appellant to commit the murder of the deceased. In a case based on circumstantial evidence, motive assumes pertinent significance, and absence of motive puts the court to verify the other circumstances minutely to see whether the chain of circumstances are complete and cogently established and it forms a complete chain or not. The evidence of PW5, PW6, and 12. No doubt proofs about the seizure of a pant and a shirt of on a seizure list, Exhibit 5. But evidence of PW5 indicates that on 24/1/2025, he came to the when he had come to his quarter to take lunch. One police personnel called him to come out, and he showed one sky-colored full shirt and one navy blue-colored full pant, and requested him to sign on a paper, and accordingly, he put the signature on the seizure list, Exhibit 5. This witness has been declared hostile by the prosecution. PW5 has not whispered anything that the full pant and the shirt which were seized belong to the accused. Similarly, the evidence of PW6 indicates that on 24/4/2004 at about 2:30 p.m. while he was in the university office at Bhanja Vihar, the officer in charge of Gopalpur police station as well as Bhanja Vihar outpost contacted him, and he accompanied the police person to the house of the deceased, and the appellant was also there, and they found one barbed wire fencing on the backside of the house of the deceased and noticed one navy blue color full pant and one sky color full shirt were on the barbed fence, and the police seized the same as per seizure list, Exhibit 5, and he also put the full pant and full shirt marked as Exhibit MO5 and MO6. Most peculiarly, the evidence of PW6 is also silent that the pant and shirt which were seized belong to the appellant. The evidence of the IOPW12 in paragraph number 9, page number 70, 71, PW12 is that PW12, paragraph 439. No, we are not on that. जो सीजर विषय की कोई जो PW6 है, आईओ जो सीजर कला, PW5 बोले, 11 बोले. ये 5 अच्छा से जो सीजर लिस्ट करेंगे जो 5 6 ଆଉ ସେ जो वेरिंग आकर से होची 11 এটা 12 ना से सीजर लिस्ट साथी हो जाऊ की पेज 67 ना. The IO bracket with PW11 has stated about the seizure in nature, and therefore, even if it is proved that the appellant was last seen in the company of the deceased at about 10:30, leaving the quarters, and thereafter the dead body of the deceased was found on the next day morning, in absence of any other clinching evidence on record, and merely because the prosecution has proved that the deceased died a homicidal death, it cannot be said that the prosecution has proved that the chain of circumstances is complete. Law is well settled that in order to base a conviction on the basis of circumstantial evidence, the prosecution has to establish all these circumstances firmly by cogent evidence, and the circumstances cannot be explained under any hypothesis, and the circumstances taken together must form a complete chain so as to show that there was no inescapable conclusion that it was the appellant, accused and accused alone who is the author of the crime.
law is well settled that suspicion, howsoever strong, cannot form the basis of conviction, and heinous the offense, higher must be the proof, and therefore we are of the view that the London trial court was not justified in convicting the appellant under section 302 of the Indian Penal Code. And we are of the view that it is a fit case where benefit of doubt should be extended in favor of the appellant. Accordingly, the jail criminal appeal is allowed. The conviction of the appellant under section 302 IPC is hereby set aside. The appellant is on bail. The bail bond stands cancelled. They put a note of appreciation on Mr. Katkia and also Mr. Nayan. Okay.
One recent judgment you also can reflect that reported in 2025 Live Law Supreme Court, section 13, Padman Vivar versus State of Odisha on last seen laws. I'm given the
right.
citation.
You say last seen law you get the quote for the
And my learned friend's name can give me. I've given the names in that.
Mr. Patki or Tankar Nata, the young one.
The young one.
Sure.
Credit to us.
If we